some of the logistics that are going to be needed continuously in the meeting. I'm going to ask Advocate Bauer to just attend to this issues of judgment and the information thereof.
Thank you, Chair. So we have endeavored to put the most relevant judgments together in a folder. If Advocate Mpofu, if you can give us, when you refer to a judgment, which case it is and the paragraph, then we will endeavor to put it up on the screen so that the members could follow, and then there would be less, then they'd be able to know what we're talking about. Thank you.
Okay, thank you. I'm hoping we'll proceed as such. Advocate Mpofu.
Thank you, Chairperson. Yes, thank you. Yes, I think that will be helpful also for the members to see what we're talking about. Mr. Ebrahim?
Just switch on your mic, Mr. Ebrahim. Thank you.
Thanks. Yeah. All right. Okay, you heard what has been said. So you have access at least to one of the screens. Yes. Okay. I owe you an apology for the reference. I couldn't find my judgment, but have you been told which passage it is?
No.
Okay. Right. Okay. It's if you go to the 2018 judgment, and as I say, I apologize for giving you the wrong reference. It's to the part that I was referring to you to is 206, paragraph 206. You got that?
Yeah.
But I think it would be helpful to do this again.
Okay.
So that, because this is crucial for this committee in particular. The aim of this part of the cross-examination is to establish for the committee, or rather to assist it to establish when it meets or whenever it makes decisions, whether this is a futile exercise or whether it should, as some of its members have suggested, seek legal advice, or whether it should go ahead regardless. Okay. Now, you are aware that there is a need in terms of section 194. I think you've said this in fairness to you in your own document. There needs to be what is referred to as an institutional predetermination of the existence of the ground. Right?
Yeah.
Agreed?
That's correct, yes.
Yes. And that institutional predetermination precedes the actual removal process, correct?
That's correct, yes.
Yes. And the tail cannot wag the dog. So you must start with the institutional predetermination. Once you have a finding, then you get into removal proceedings, correct?
Yes.
Yes. And the part that I'm going to read to you establishes that, and then I'll come back to the question that I was going to ask you. If you indulge me, let's go back to 204. It says, but the process and decision, section 89(1). Okay, I'm sorry to do this. So every time when I say section 89, that's why I had this 289 in my head. Every time when I say section 89, for the purposes of this discussion, you must substitute section 194. You understand the exercise? Do you understand the exercise? In other words, an impeachment process for the president is not what we're busy with here. Well, it's public protector, but I'm talking about the principle. Do you understand?
Yes.
Pardon?
Yes.
Yeah. Okay. So when I say section 89 in your head, you must think 194. Okay, but the process envisaged in section 89(1), that means in an impeachment process, involves necessarily an antecedent determination by the assembly to the effect that one of the listed grounds exists. Do you agree with that?
Yes.
And this is because those are grounds for the president's removal. With regard to the motion, this was not done. It was simply tabled, debated, and voted on. Right? Now, you said in your testimony that when it comes to the process, it is an identical process, whether it's the president of or the public protector, correct?
Correct.
You did, in fairness to you, make the distinction that when it comes to the merits, the standard to be satisfied, what my learned friend, there's a hierarchy. But we're not talking about that now. We're talking about the process, which is identical, correct?
Yes.
Right. Now, it says, the Assembly did not approach the process of the motion on the footing that the President had indeed committed serious violation of the Constitution. Don't worry about that. That's on the facts of that matter. Here's the important part. This was a necessary condition for commencing a Section 89 process. You understand what that means?
Yeah.
That the determination of the existence or non-existence of the ground is a necessary condition for the commencement of the process, of the impeachment process.
Okay.
Agree? You agree with that?
Yeah.
Yeah. Now it says, without accepting that one of the listed grounds existed, and the word existed is important, the Assembly could not authorize the commencement of a process which could result in the removal of the President from office. You agree with that?
Yeah.
And it goes back to where we started, that the one process is, you cannot do the second one without having done the first one. You can't do the removal process without having done the determination of the existence of the ground process. Agreed?
The predetermination related to
Existence of the ground.
And the definition that needed to be utilized. So it was a predetermination of really what meant by misconduct, serious misconduct, whatever. It's not a question of the grounds. It's a question of really the predetermination of the definitions, so as to ensure that there was no dispute around what was meant by misconduct or serious misconduct.
No, Mr. Ebrahim, please. But that's the same thing. That's the ground for removal, isn't it?
Yeah, it was a definition of the issues.
But that's otherwise known as the ground.
Yeah.
Yes, good. Yeah. So I don't know what we're debating now. Now, it says, moreover, it does not appear from the papers the President was afforded an opportunity to defend himself, not knowing whether the Assembly holds the view that the President has committed a serious violation of the Constitution. It would be difficult for him to mount an effective defense. The procedure followed by the Assembly here does not accord with Section 89. That's where I wanted to start.
Yeah.
What I was asking you before lunch. So for whatever reason, if the procedure does not accord with Section 194, then I was saying to you, that would mean that the process is liable to be set aside, to be reviewed and set aside.
Yes, it has to comply with the Constitution, yes.
Yes. Okay, thank you. I think the lunch assisted. Okay, 206, the paragraph 206. If that motion had succeeded, in other words, if the motion which was tainted by the illegality had succeeded, it would not have constituted impeachment and removal of the president as contemplated in Section section 89(1). Usual rules. Agreed?
Yeah.
Instead, it would have been an unconstitutional removal of the president from office and would have been liable to be set aside on review. That's the real issue I was putting to you on before lunch. Do we now agree?
Yes.
Good. Right. So now let's come to this procedure to see whether it is the one described here, which would be a waste of time, or another one which might serve some purpose. All right. Now, you said something that worried me a bit, so I would like you to explain it. You said section 194 does not concern the person, but it concerns an institution. That was a source of some confusion here yesterday, and I don't want you to add to that confusion. Is that what you said?
Excuse me, please say that again.
Did you testify in chief this morning that section 194 does not concern a person, but concerns an institution, an office?
Yes.
You did? Okay,
Yeah.
good.
Removal from office. 194 deals with removal from office. So it's a removal of a person from the office, yes.
Oh, sir, please. Did you or did you not testify that section 194 involves the removal of rather concerns the an office and not a person?
No, it's not removal of the office, it's removal of the person. You have to, section 194 reads, the public protector, the auditor general, or members of the commission established by this chapter may be removed.
Mr. Ebrahim, you know, you'll spend a lot less time if you listen to the question and answer it. Yeah. Did you, Mr. Ebrahim, yes or no, say this morning that the section 194 concerns an office and not a person? Either you said it or you didn't say it. You didn't say it.
Remove of the person from office. That's
okay,
what it says.
I'm trying for the last time. Mr. Ebrahim, did you?
Yeah. So thank you, Advocate Bauer.
He has not answered the question. It's a simple yes or no. He said it or he didn't say it. Did you say this morning, or did you not say that section 194 concerns an office and not a person? I mean, how difficult is that?
It's removal of the person from the office.
Yeah, he's repeated that again.
No, he must answer the question yes
he's
or
answered
no.
the question. You might not like the way
it
he
doesn't
answers
matter.
the question.
He's answering it now, Chairperson. I'm asking about the morning, please.
He's clarifying himself what he said. You might have to help us. Just hold, Mr. Mpofu. You might have to help us. You were here. You make that specific reference in his presentation. He's in front of you, so that we deal with that specific issue.
Thank you, Chairperson.
And not throw a general question.
Thank you, Chairperson. It's not a general question. It's not general. It's you, Mr. Ebrahim, not general.
Can you point us now to that?
There's only one, Mr. Ebrahim. Yeah. Yes. It's not general.
Point us, Mr. Mpofu. Please point us to what you want him to respond to. It's in his presentation.
Chairperson, you want me to continue with this exercise?
I want you to assist us, so that we're with you.
Then let me ask a question. I'm asking a very simple question.
You have asked that question more than 3 times.
It has not been answered.
He answered the question in the way he understood it.
Okay, what was the answer?
He said to you it's about the removal of the public protector from the office.
That's not what I asked him.
So what is it that you're asking?
Okay. I'll do it.
Can you point us to this presentation?
I'm not pointing to anything. I'm asking a question. I'm saying, I can't believe how simple this thing is. It's like, did you, if I'm saying, Mr. Ebrahim, did you fly this morning from Johannesburg? Yes or no? I mean, simple. Did you say this morning that Section 194 concerns an office and not a person. I mean,
I said very clearly that it is a question of the removal of a person from the office. That's what Section 194 says.
okay, I give up. All right. And let me remind you again, sir, and for the purpose of the process, your job here, I thought, is to assist the committee, not to be evasive, not to try to assist or not assist any side. It's simply to come and assist. So really, you are the one witness for whom the answers should be very easy because you are just helping all of us, I thought. But it's fine, I give up on that question. Now, whatever you said or did not say this morning, do you accept now that these proceedings concern a person, not the removal of an office?
That's correct.
You accept that?
That's correct.
So just a pause, Mr. Ebrahim. Honorable Mulder.
Advocate Porfo is suggesting that we are here to remove an office. That's what you've just now said. Read what says Section 194, removal from the office. Nobody said removal of the office. I don't understand what's going on.
That is true. Okay. The witness said you'll be embarrassed when you read what he said this morning, which is that Section 194 does not concern a person, but concerns an office. He said it. You may not have heard it or whatever, but when you read the record, as I say, you'll be embarrassed. But or at least one of us will be when the record speaks for itself. Yeah. But be that as it may, it's, well, you've denied saying it, and now it's also being denied on your behalf, but the record will speak for itself. Now, if we then agree that it is about the removal of a person, right? Then you would also agree that the suspension of that person must be done in accordance with Section 194(3)(a).
That's correct, yes.
Right. And you'd also agree that if there is non-compliance with that section, that would affect the fairness of the process.
If there's non-compliance with Section 194(3)(a).
Yes, it would have an impact on the fairness of this process. In other words, if there's an unlawful suspension or premature suspension of a person, then the process itself would be tainted by that illegality.
I don't agree.
You don't agree?
I don't
Okay.
agree. They're two separate issues, if I may explain.
Sir, I know they are separate issues,
Yeah. So,
but they are all, they're both contemplated in Section 194(3)(a),
Yeah.
no?
that's correct, but they're two separate issues. The suspension of the public protector in terms of 194(3)(a) is quite a different put to the question of dealing with this a resolution concerning the removal of office.
How can that be if the suspension is dependent directly on the process for the removal?
The issue really is the suspension takes place, if I may read it, it says may suspend the person from office at any time after the start of the proceedings. So if the committee had started working, it would be sufficient enough to allow for that suspension to start to come into operation.
Right. And if the removal proceedings have not started?
If the committee had not started work,
No, so don't talk about work. There's no, do you see the word work here?
no, after the start of proceedings of the committee, yes.
So if the removal proceedings have not started?
That should take place after the start of the proceedings of the committee.
Thank you. And we know that because, as we have just read in that section, in 206, that the what you have called the institutional predetermination has to happen before.
Yes.
Okay. And if you go to paragraph 178 of that same judgment, 179, sorry. Yeah. For the impeachment process to commence, the Assembly must have determined that one of the listed grounds exists. Do you agree with that?
Yes.
Yeah. So until the predetermination of the existence of the grounds has been finalized, the impeachment process or removal process cannot commence. You agree?
Yeah.
Thank you. And if it doesn't commence, then you also cannot suspend before its commencement, correct?
Correct. The committee has to start. Yes.
Thank you. That's all wanted to establish on that score. And you would agree that what we call the institutional predetermination stage is where we are now of the existence of the ground, sorry.
No, the institutional predetermination has already taken place.
Oh, when was that?
I thought that took place with the definitions identified in what the definitions of misconduct and was.
So again, I've asked you a simple question. When was that? You said it has already taken
That's
place.
in the document that was put together.
Oh, you mean when the rules were adopted?
The rules, yes.
All right, that would be the 3rd of December, 2019. Well, I'm just telling you, that's when the rules were adopted. So you're saying the removal process started then?
That's what if the dates, I don't have the.
No,
dates
assume I'm
before me.
correct with the dates.
Yeah.
The rules were adopted on the 3rd of December 2019. So
Okay.
in your expert analysis, that's when the proceedings started.
Yes. Yes.
Thank you. And you seriously think that's what Justice Chafter meant by that there must be an institutional predetermination of the existence of the grounds?
That's my view, yes.
Thank you. Okay. I think for what it's worth, we will continue, but I think we could even stop right here. So effectively then, there was no need for this judgment of the Constitutional Court because all that needed to happen would have been for rules which define what serious misconduct in the case of Section 89, and then off we go.
May I read to you what the document says and what my submission was? May I?
Yeah, you can do that, but you must just answer the question first.
In paragraph 93.3, this is what was said, okay, of my document that I submitted to you. Under the Constitution, only the National Assembly may remove the President from office. The Constitution does not define the grounds of impeachment, including what constitutes serious misconduct, and has left the detail of those definitions to the National Assembly. However, the Constitution's intent was not to leave the definitions up to the individual members, else there would be divergent views on what amounts to serious conduct. Accordingly, there must be an institutional predetermination of what constitutes serious misconduct. That's what I said.
Yeah.
Okay.
But you and I agreed a few minutes ago that we are the institutional predetermination of the existence, whether it's misconduct or serious misconduct, encompasses an inquiry to do that.
It doesn't necessarily encompass an inquiry, no.
Oh,
The predetermination is not an inquiry. It's the definition, it's predetermination, and the committee has to apply its mind as to what constitutes misconduct, and that has been defined.
yeah. All right. No, that's fine. We'll come back to that.
As you continue, so Mr. Ebrahim, and that has been defined where in the rules of the National Assembly, as you read to us today?
Yes.
Okay.
Yes, like you said, in other words, on the 3rd of December, 2019. Assuming I'm correct on the date.
Yeah.
Right. Okay.
And if I may just be more clear, in paragraph 92.5
Of your,
of my submission,
oh,
it's headed definition of misconduct. It says the removal rules define the concept of misconduct with reference to gross negligence and intention, which forms of fault are not prescribed by the Constitution. This, however, is entirely permissible. Yes. So the definition of the misconduct had been clearly specified, and that was what was included in the removal rules.
yeah. No, I understand. I think we're together. No, I think it was the chair who just wanted to emphasize. I was saying both what you and him are saying, then place that the event happening of that event on the 3rd of December, 2019. Agreed?
I'm not aware of the exact dates, but that's what I submitted.
Yes. And according to you, seriously, that is what the Constitutional Court meant when it says the following. Without accepting that one of the listed grounds existed, just that, does that, in your estimation, involve an inquiry or not into the existence of that ground? Not the definition now, whether it actually exists. In other words, whether the person, whether there's misconduct or gross misconduct or whatever.
Yes. The issue there was that there was no predetermination of really the definitions and that was identified. And so the grounds itself, it had to be clearly specified, yes.
Okay, I think just to be fair, let me give you a second chance at this one. You are seriously suggesting to this committee that when the Constitutional Court says there must be a determination of the existence of a ground, that simply means a definition, not the inquiry into the actual existence, the establishment of the ground. Is that your evidence?
My evidence is that there must be predetermination so that there be a common understanding of really in the rules what would constitute misconduct.
You've already said that. That's the definition. Yeah. I'm saying once that is done, you think that this reference of saying that you cannot authorize a commencement of a process which can result in the removal without establishing that the ground exists And I said to you when I was reading it, underline the word exist. You're sticking to your version that is not an inquiry.
I'm sticking to my version. The point here is that there has to be a predetermination of the definitions of really what is construed. And then the committee starts. And once the committee starts, the suspension can take place.
Yeah, but what committee? I mean, when they adopt the rules on the 3rd of December 2019, there's not even a complaint. So you are saying that even before there's a complaint, I don't even know how to say it. The existence of the...
Just a pause, Honorable Hassen.
The existence of the ground can be determined, sorry.
I'm sorry, Chair, and sorry, Advocate Mpofu, to interrupt.
So sorry,
but
no
can we
problem.
get the paragraph on the screen that,
Yes.
as we did with the previous judgment?
Yes, okay. The one I'm reading on now, Mr. Heron, is...
It's the
It's
19,
205.
the 2018 case,
Yes.
paragraph 1/7.
No, I started at 178. The one I'm reading to him now is 205. Please, whoever, I don't know where the person is. Yeah. Are you okay? Thank you. Okay, Mr. Ebrahim, as I said, I gave you a second chance just so to be fair. And you're saying you're sticking with your answer. If you go to I asked you to read at 179. Just go to the next paragraph, which is 180. So that it's clear that what you're saying is wrong about the absence of an inquiry, or that is just about definitions. It says that, therefore, any process of removing the president from office must be preceded by a preliminary inquiry, during which the assembly determines that a listed ground exists. I've been trying to explain this. The form of this preliminary inquiry depends entirely upon the assembly. Okay, that's obvious. Maybe an investigation or some other form of inquiry, also up to the assembly to decide whether the president must be afforded a hearing at the preliminary stage. Do we now at least both agree that that predetermination involves an inquiry? Please answer.
Yeah, I'm just having a look at 180. Therefore,
Take your time, take your time.
Sorry?
I'm saying take your time.
Thank you very much, sir. Yeah, 180 is fairly clear. It says, therefore, any process for removing the president from the office must be preceded by a preliminary inquiry, during which the assembly determines that the listed ground exists. The form which such a preliminary inquiry may take depends entirely upon the assembly. That's what it says.
Yes, you just read what I read to you. That's not my question. My question is, do we now agree between you and me that institutional predetermination involves some form of inquiry on the existence of the ground?
I think we're referring to two different things. We're referring to two different things. Here is the court is referring to an inquiry, a preliminary inquiry. It says there must be a preliminary inquiry during which the assembly determines that the listed ground exists.
Okay, let me make this simple. Do you accept as a matter of just generally, as a human being, that the existence of a ground for anything, whether it's in a labor law or whatever, is determined only by an inquiry?
No, not necessarily, no. Why would that be the case? The existence of a ground could be based on a complaint. There's a complaint that there was misconduct.
Yes.
There's a ground,
okay. No,
which clearly states this is a ground, there was misconduct based on this. And that's a ground. It doesn't require an inquiry, it requires an inquiry to determine that.
All right. Okay, let's use that analogy of yours. So a complaint, let's say I go and complain at the police station. And I say, so-and-so assaulted me. That's the complaint, okay? And then we say, now there must be a determination of the existence of that criminal ground of complaint. Can that be determined without any form of inquiry or trial or whatever?
I still think you are conflating two things.
What are they?
The one is a predetermination. The predetermination relates to a very clear requirement, which is the Constitution doesn't define misconduct. The assembly is called upon to define that. And that's where the predetermination takes place. What you are referring to with regard to section 180 is really the inquiry. So the inquiry is based on a complaint. It's not, it's based on the definition. Okay.
Sorry,
the Constitution identifies clear grounds on which there could be a removal. Those relate to misconduct and serious misconduct, depending on which you look at. What the Constitution, what is required of the National Assembly is for a predetermination to take place. And that predetermination requires a definition of really what misconduct really would mean. Okay? And that took place. That predetermination took place in terms of the rules. Okay? What you are referring to in this is not the question of the predetermination. It doesn't talk about the predetermination. It talks about the inquiry.
I see.
It's subsequent to the
So you're saying
predetermination of the grounds.
Yeah, that's what is referred to in 180 in your estimation is different to that which is referred to in 178. If you can roll up to 178. Okay.
Yes.
Well, it says this means there must be an institutional predetermination of what serious violations of the Constitution of the law is. The same must apply to misconduct, what have you. This is evident from the language. Once more, it is left to Assembly to determine the circumstances under which the president removed from office on one or two grounds may forfeit benefits. Then says, for the impeachment process to commence, Assembly must have determined that one of the listed grounds exists. Do you understand the difference between existence and definition? Or are you saying there's no difference?
No, it says, and since the determination of these matters falls within the exclusive jurisdiction of the assembly and it alone is entitled to determine them, this means that there must be an institutional predetermination of what a serious violation of the constitution or law reform or law is, which is that they need to define the definition of a serious violation. Yes.
Okay,
Okay.
let's
The same must apply to serious misconduct. So it must define in that predetermination what serious misconduct is, and that should be in the rules. And the inability to perform the functions of the office. The acting speaker, I think that speaks for itself.
Yes. Okay, Mr. I promise you we're going to move on now because I don't think we're going to make any headway, but I'll give you a last chance. And here, when I read this, you must concentrate on the two words, exist and established, okay? Okay, so next paragraph. For the impeachment process to commence, the assembly must have determined that one of the listed grounds exists. Then the next sentence, this is so because those grounds constitute conditions for the removal. A removal of the president when none of the grounds is established would not be a removal contemplated in terms of section 891. Do you agree with that?
Yeah.
Do you also saying that the establishment of the existence of a ground simply means its definition? Are you seriously saying that?
That's what I'm saying, yes. It needs the definition of misconduct.
Yeah.
And serious misconduct need to be set out. And that's what was set out in the rules. It's a predetermination of what they are. You cannot hold an inquiry without actually doing that.
Without establishing the existence of the ground?
No, without establishing really what misconduct means.
But can you do it without establishing the existence of the ground?
The existence of a ground is quite a separate issue.
Yes.
Because the grounds are identified, the basis for removal are identified in the Constitution. What isn't identified is a definition of what that means, right? What misconduct really means. And therefore the rules, the National Assembly had to predetermine through its rules what misconduct means. And once it had done that, at least it could then proceed.
Thank you. No, I understand that part of your answer. We've gone through it ad nauseum.
Just a pause, Advocate Mpofu. Just a little pause there, apology. Just before he comes in, once those rules were concluded, what was the next step that happened?
The inquiry takes place. Then the National Assembly is entitled to pursue the inquiry.
Do you mean the panel?
Yes.
Oh,
No, not the panel, but the committee. Even if any committee established by the National Assembly, an inquiry takes place. What 193, the reference to...
I'm seeking clarity, Advocate Mpofu.
Okay.
Please don't interfere.
Seeking clarity by introducing something that the witness didn't say.
I'm seeking clarity. Please conclude. Conclude, Mr. Ebrahim. You done?
Yeah, thank you.
Thank you, Advocate Mpofu.
Okay. You know, Mr. Ebrahim, unfortunately, I have to ask you these questions. And unfortunately, we need to make sure that this committee doesn't say one day it did not know, the Nuremberg defense, whether it's involved in illegality or not. I'm saying to you, simple question. Do you agree that there cannot be a removal process without establishing the existence of the ground, not its definition, the existence of the misconduct, the incompetence, the incapacity as defined? Maybe let me help you like that. Let's assume the definition already happened 100 years ago. Do you accept that there cannot be a removal process without establishing the existence of that ground that was defined 1,000 years ago.
All that is required in terms of a constitution is that the committee needs to be established dealing with the inquiry based on the allegation that there had been serious misconduct.
True.
Sufficient.
Yeah, that's true. But do you then accept that until that committee makes a finding as to the existence or otherwise of the ground, the alleged ground, then that inquiry, or rather that removal cannot take place?
I'm not sure what you're referring to, but I'll tell you what the Constitution says. Perhaps I can read it for you. It says the President may suspend the person from the office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Don't talk about anything else. Once a committee has been established for the removal of the person, the suspension can take place.
Right. So now you're changing your evidence.
No, I'm not.
No, let me tell you why, to assist you. You're saying two different things, and I'll assist you by giving them dates, okay? Yeah. The definition of the offenses, for lack of a better word, was done on the 3rd of December 2019, right? The establishment of this committee happened on the 16th of March 2021. Those two dates cannot be the same date. We agree on that.
Yeah.
Yes. Now, which of those two dates are you saying, are you talking about when you're saying there was a predetermination of the...
Once the rules were established, defining what misconduct and serious misconduct was, that was the predetermination that was required. It then offered the National Assembly the opportunity then to institute and establish the committee, which would be then as referred to 194.3a.
And that committee, its job is to determine whether the alleged grounds exist, correct?
No. You are saying something, you are reading something into it which I cannot read in the Constitution. The Constitution is very clear. It says the President may suspend a person from office at any time after the proceedings of a committee of the National Assembly for the removal. If the committee has been established, at any time after the committee has been established, the President may proceed with the removal. However, what we agreed is that the committee needed the predetermination, and predetermination of what constitutes misconduct had to be in the rules, and that was clearly set out in the rules.
Okay. All right. I'll read it to you what it says in the rules, and then you'll tell me if that is the same thing. So the committee must, when the Assembly has approved the recommendations of independent panel in terms of rule. Yes, you can. Okay. The committee must, when the Assembly has approved the recommendations of an independent panel in terms of Rule 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. Do you understand that? Establish, that's the word I said you must underline when I was reading the Constitutional Court judgment. Establish the veracity of the charges.
So which rule are you referring to?
I'm sorry, it's 129 AD. Sorry, Mr. Ebrahim. 129 AD.
Yes, Minister Madam.
Yeah, perhaps this is I'm trying to follow here, and I'm perhaps not understanding clearly. And I really want to understand the nature of your question, Advocate Mpofu. Are you suggesting that for the suspension to take place, the committee has to make a finding first. Is that what you're trying to lead up to? Or are you suggesting that there is, at some point in the committee process, the suspension can take place? I'm trying to understand where you're going with this.
Yeah, no, that's a good question. That's where I'm going. Yeah, right. Yeah, right.
Sorry, you didn't answer my question.
You said, am I establishing whether there must be a determination, or rather an inquiry which has a finding or a determination, or whatever you call it? Yes.
So you're saying that there must be a finding before suspension can take place?
Yes.
Like yourself.
Thank you, Chair. So the advocate is suggesting that this committee must make a finding before a suspension can take place.
Yes, it's not the advocate, it's the Constitutional Court. Yeah, it says that there must be a institutional predetermination of the existence of that ground. Yeah.
So, yeah, I understand what the Constitutional Court says. What I'm asking you, and the Constitutional Court speaks specifically to the removal, does not talk to the suspension. So my question to you, advocate, is whether or not this committee has to make a finding before a suspension can occur.
Yes, that's what I'm saying.
I understand.
Okay.
Thank you, Mr. Ebrahim.
Do you understand the issue now?
I understood the issue all along. The point is that I don't agree with you.
You did? Okay. Do you also not agree then with the following sentence? You don't agree with the Constitutional Court or with me? It says equally, I'm reading on, I don't know if it's up. A process for the removal, that answers what Mr. Mayhem has just said. A process for the removal of the president when none of those grounds exists would amount to a process not authorized by the section. Do you agree with that at least?
Yeah.
Okay.
The issue is really the ground would refer to the definition of what misconduct is, not the fact that
it exists.
Yeah.
So the line, chapter J, when it says where none of those grounds exist, he was just what? Hallucinating.
No. You are referring to two things. You are conflating two issues. The definition of what the ground is and the inquiry related to that.
Right. Okay, thank you. I think that is as helpful or unhelpful as it can be on that score. But okay, no, I don't think it's going to help us for me to even read the next sentence. Right. Now, we were saying before lunch, I was saying to you that let's do this comparative analysis between the role of the public protector and the role of a judge. Remember that? Yeah. Now, it is true that, and I think it's contained in your statement, that to some extent, the role of a public protector is similar to that of a judge.
No.
No.
I pointed out very clearly to you when I referred to Bishop and Woolman, the paragraph is very clear. May I remind you what it said?
Yeah. It says the opposite of what you're saying now.
No.
You'll find it at your paragraph 24. The passage from Woolman. Read the first sentence.
Bishop and Woolman described the public protector's office in the following terms. It says the public protector's purpose is profitably compared to the role of the judiciary.
Yes. Okay, let's
The
stop there.
courts handle discrete disputes about law and conduct. They rely on correct procedures and solid, sometimes intricate legal argument. Courts are simply not designed to handle the large number of complaints that arise from simple misunderstandings or bureaucratic red tape, nor do they lend themselves to the resolution of injustice that turn more on unfairness and illegality, which is really what the public protector deals with. The public protector occupies a middle space in the political constitutional landscape. It serves the public by and assists the courts and the legislature.
Yeah.
It assists the courts by addressing those complaints about administration of justice that fall beyond the court's purview. So it's very different. So
Okay.
when you profitably compare, then the two deal with different things. So that's the comparison is about the difference, not the similarity.
Okay, let me ask you differently. Do you agree that the public protector, similar to the courts, also deals with the administration of justice?
There's no question about it. It's
Thank you.
different parts of the administration of justice.
Thank you.
The public protector will deal with unfairness and the courts will deal with illegality, the compliance with the law.
Yes, and
Two
therefore,
are different.
I'm
They
sorry.
both deal with administration of justice.
They do. Okay, good. And to that extent, the public protector assists the courts.
Correct.
Thank you. That's all I wanted to say. Intersection. Secondly, you also agree that the remedial action of the public protector is binding, as are court orders, correct?
Yes. And can only be challenged on the judicial review.
Correct.
No question.
And thirdly, you would agree that there's no other constitutional public office holder who is protected by contempt of, somebody going to prison for contempt.
Correct.
The only persons who have that protection, constitutional protection, are judges and the public protector.
Judges don't, courts do. It's a distinction. The public protector is not in the Constitution. It's by the Public Protector Act under the subheading of contempt of the public protector.
Are you being serious now? So judges are not protected by contempt?
It's the court that is protected.
Yes, I know the court
Contempt
is
of court.
protected.
You have contempt of court proceedings.
Yes. Are judges not protected by the offense of contempt?
I'm clear of the offense of a contempt of court. I'm not sure if I quite agree about the contempt of a judge.
Okay. So if you insult a judge and if you insult the public protector, you go to jail.
If you insult the public protector, you're clearly going to go to jail in
Yes.
terms of the act.
And if
No
you insult
question
a
about
judge,
that. I'm not aware of the offense. Perhaps you could enlighten me. Do you?
have you ever heard of a case called State versus Mama Bulo? By Krikla. Jay?
No.
Okay, you don't have to know that particular case. But your evidence is seriously that if you insult a judge, then you're not within the ambit of contempt.
No, I'm not. That's not my evidence. My evidence is merely I'm not aware of that. I'm clearly aware of the crime of the offense of contempt of a public protector. I have I've cited that in the act, and that's in the Public Protector Act, which is an unusual offense.
Yes, not only is it unusual, it's unprecedented. I'm saying that that is a protection that is given to the public protector uniquely.
Correct. That's my understanding.
I'm just trying to assist you so that next time, if you ever testify in these things, you should know.
Where are we now, Advocate Mbofu?
In what? In terms of geography or?
No, you don't respond. You don't respond to me like that.
Where?
I'm asking you're now saying you want to assist him for the next, in case he appears exactly. I mean, the kind of language you're using here consistently is becoming disrespectful.
What are you?
And now I'm asking you a question talking about geography. Where's geography to do with the question that I'm asking, which is very specific?
No, I don't know what you're asking. Chair. I'm trying to understand. What is the question?
I will not repeat that question.
Thank you. All right. Yes, okay.
Personally, we all have lots of things to do. It's not for, really, if you want to assist the witness for future reference, please don't waste our time doing so.
And Chair, you'll allow that kind of language?
No, he's asking you not to waste our time, Advocate Mbofu. And it's important.
Thank you.
And perhaps you need to indicate how far you are on the kind of questions you're going to be putting forward.
Yes. If you go to section 9(1)(b) of the Public Protector Act.
Advocate Mayosi, just a pause.
Sorry, before you proceed, Advocate Mbofu, could you perhaps give us the citation for S versus Mamabolo?
No, I don't. I'll give it to you later.
You don't have it now.
No, I can find it. That's what I was saying. It doesn't work like that. If you need a citation, it means you must wait for it. Then you have to wait for it. And then you tell me I mustn't waste your time. I mean, which is which? I can find the citation, but if you want me to find it.
It's not you have a team here, Advocate Board. That's why you have this team behind you.
Yes, but even the team is not sitting here on S versus Mamabolo. That's what I'm saying. So should you want us to wait for the team to find it? Okay.
Okay. Honorable Lagode.
Maybe the team. Can you find it?
Thank you very much, Honorable Chairperson. I think this is section 194, the parliamentary inquiry. Then in Parliament, when we are doing our work, when you quote something, you should distribute the documents to all members so that we can read from what you are quoting. But if you don't have that, please don't quote because we have nothing to refer to.
Yes.
Thank you very much.
Thank you, Honorable Member. I think that's exactly why I did not quote that case. But thanks.
Can you please proceed with your questions?
Yes. The question is, section 9 says that no person shall insult the public protector or deputy public protector.
Yeah.
We agree that that refers to the person.
That's what it says.
But it refers to a person, not an office, to a person.
Yeah.
Yes. Okay. And then it says, in connection with an investigation, do anything which, if the said investigation had been proceedings in a court of law, would have constituted contempt of court. Now, the simple question I was really asking you is, on a reading of that question, or rather of that section, would you agree that it therefore, in terms of contempt, equates the public protector, that is the person, to a judge? In other words, if you were to insult a judge, you'd befall the same, you'd be befallen by the same fate.
I don't think I can agree with you. You're referring to a court of law, proceedings in a court of law. If the said investigation had been proceedings in a court of law, which would have constituted contempt of court.
Yes.
Yeah.
Yeah, in other words, if you had, instead of, if the person you are
Contempt of court.
insulting was not a public protector now standing in front of you, but a judge.
Yeah. Basically, if I understand section 9 clearly, it merely refers to no person shall insult the public protector or deputy public protector. It's fairly basic. You cannot insult the person.
Yeah, no, that's fine. We'll deal with that, I think, at the end. I'm also leaving that question just to, so that I don't waste the time of the honorable member. I think the section speaks for itself. Right, now we agree, you agree that the powers of the public protector are very wide.
That was my submission, yes.
So wide that it's difficult, if not impossible, to define their limits.
They're defined by the only two limits to that would be the question of 2 years.
It's a question. Yes, and you know, you're quite right. When I say limitless, I'm using, I mean, in the sense that obviously the rule of law will constrain it.
Doesn't mean much.
But apart from the, pardon?
It's extensive.
Yes, but do you agree that apart from being extensive, the limits are not easy to define?
There's no definition on that.
Yes. And that is important because some of the charges here relate to whether those powers were exceeded in certain cases, and in certain cases, whether they were not practiced. I don't want you to get into the merits. I'm just telling you the importance of the question. Now, the question for you is whether the public protector has got the ability, for example, if a complaint comes, to extend the scope of the investigation or even to limit it.
Not to extend the public protector may not extend the investigation.
Really? Have you read the Mail and Guardian judgment?
Yeah.
You have?
Not to, they do not extend investigations beyond the state of affairs into the affairs of private entities. So, yeah.
Sorry? Okay, let me ask you a simple question. Don't worry about the beyond whatever. Do you agree that the public protector has the capacity to extend the scope of a complaint?
I don't think so. I don't think so.
She doesn't have a discretion to extend a complaint?
The scope of it, no.
Okay. Does she have the discretion to limit it?
I suppose if there were reasonable grounds on the basis of which to do so, they were justifiable, yes.
And if there were reasonable grounds to extend?
If there were reasonable grounds to extend it, that could also be done.
Right. All right. And one of the, again, I'm giving you this for background. One of the key charges here is about the so-called CX matter. Are you familiar with that? That's the one about the Absa lifeboat.
Yeah.
Yes. And the big issue which has been presented by those who brought us here is that the public protector's remedial action would have necessitated the amendment of the Constitution. You must remember that, even maybe just from, if you haven't read the case. You remember that? Yeah. So you must say yes so that it records.
Yes, yes.
Thank you. Now, you do agree that the extensive powers of the public protector may even extend to those matters which might necessitate a constitutional amendment?
No. I'll tell you why. Because according to the constitutional definition of an organ of state, there could be no encroachment of powers between the organs of state. There could be remedial action. Yes, there could be remedial action. And I believe that the public protector has a right to issue remedial action. Yes.
Oh, I'm asking a different question. I'm saying if she issued a remedial action that might necessitate constitutional change, would that be misconduct in your estimation?
Chairperson, it doesn't matter that goes into the merits of the case. I really want to steer clear from the merits of the case. This is not my terrain. It's not my remit. It's not my brief. And so it's a matter that is really beyond.
No, but sir, you told us for the whole morning about where the powers can be circumscribed. So it's too late now to check up.
So are you indicating that you're not in a position to answer that?
No.
Thank you. Proceed with all of that on both.
So you're not in a position to tell us whether the limits, or rather whether the extension, which you and I have agreed might be needed on reasonable grounds, may or may not include issues which might require a constitutional amendment.
No.
They are unable. Okay. And just generally, other administrative bodies, to your knowledge, as an expert of some sort, to your knowledge, other administrative bodies can make proposals that involve constitutional amendments without being impeached?
Well, constitutional amendments can be raised by whether a body of parliament or from outside. There's no question of that.
Including the public protector?
As a public protector, yes, as a public protector.
As a public protector
wishes to make a submission.
Thank you.
That there ought to be an amendment of the Constitution that would be entitled just like anybody else in the country would be.
No, thank you. That's very helpful. Thank you very much. And then you agree that also the public protector should not be held responsible for legal advice that she might obtain. Whether it's correct or not correct is another matter.
Just repeat that.
Would you also agree that the public protector should not be held responsible for legal advice that she might obtain from lawyers, whether external lawyers or internal lawyers?
She should not be held responsible for that.
Yes.
I'm not sure what your question really is.
Would you agree that if the public protector in good faith accepts legal advice, that is not her fault? Let me put it that way.
Well, the public protector is required to be a person of at least 10 years of legal experience and a legal expert in the field, and supposed to be familiar with the law, is required to have that familiarity with the law. And therefore, on the basis of that, if the public protector wishes to accept a view, then the public protector as an expert in her own right, as a legal expert, it's not a question of fault or not, but she has taken the decision to accept that legal advice and adopted it.
I don't understand the answer again.
The
I'm
answer is a
asking
very
you a
simple
simple
one.
question.
The public protector is required by law to be a lawyer of substance, regarded as a senior legal officer. And that senior legal officer obtains legal advice. As a senior legal officer, receiving that advice and adopting that advice, there's no legal question about it. The public protector has adopted that position.
The public protector is what?
You're asking whether the public protector may accept advice from a legal advisor.
No, okay. I think that's the problem. That's not my question. Do you accept that if the
just a pause, Advocate both Honorable Melder.
Sorry, Chairperson, I think I'm just trying to assist. I think, if I may, I think the question is, are there certain legal advice that the public protector may receive from certain legal advocates that she should rather not accept or not be responsible for?
I'm not aware of any compulsion to ignore legal advice.
To ignore, yeah, okay. Well, that was Honorable Mulder's question. Let's come back to my question. I'm saying nothing to do with ignoring legal advice. I'm asking you a different question. Do you accept that if the public protector receives legal advice and implements it in good faith, and that legal advice may have come from senior counsel or external people or even internal people, that then she's entitled to implement that advice if she accepts it in good faith? Simple.
There's no reason why not. As I said, the public protector is regarded constitutionally as an extremely senior legal officer, and having adopted a particular legal advice, that would be it.
Purpose of the question, would Advocate Mpofu be suggesting that if the public protector then acts on that wrong advice, that she will not be responsible?
Are you cross-examining me?
Could I repeat the question? Yes, I'm addressing Advocate Kali Mpofu.
Oh, thank you. Yes.
Let me try again.
Okay.
I'm trying to get behind the gist of your question.
Yes.
Understand the gist of your question? It is that if the public protector receives legal advice and she acts on that advice and the advice is wrong, that she would not be responsible. Is that the gist of what you're trying to say to us?
Yes.
Okay, thank you.
Yeah.
Mr. Chairman, I told you yesterday I have a quarrel. I've got another quarrel today. I cannot understand why you allow Mr. Ebrahim Patel to be questioned when the advocate says you're not an expert and then starts questioning you as if he's an expert. I can't come around that, right? Then secondly, I also mentioned the fact it costs us R1 million a day, the fiscus, for legal costs. We've already dragged this for 2 years. We've already gone 2 days. I don't want to listen to experts and people say, but you're not an expert, Mr. Patel. I want the veracity of the allegations to be tested by us. So why don't you, Mr. Chairman, put the allegations before us, give the version, and get the public protector to have a so-called day in court and answer to that. Why are you dragging this? Why are we involved with procedural matters? Can't we get to the crux of the matter?
Thank you, Honorable Hendricks. I understand your point. I sympathize with it. That time will come. There are certain steps that we've got to navigate and go through. We have I'm speaking now. We have the first witness in front of us who had taken us through in a comprehensive presentation on that institution and that office. It's in the nature of such hearings that not everything that is going to be engaged on will be palatable and would be what you expect. So we will get to that point. We're starting tomorrow with the witnesses in relation to some of these issues. So thank you. Thank you, Honorable Hendricks. Honorable Nwala?
No, Chair, I just want to say it's Mr. Ebrahim, that is not Patel. Thank you.
That's okay. There is Ebrahim Patel, so that's the issue that he might have confused. So please forgive him for saying that. Advocate Mpofu, I'm coming back to you, and I'm hoping that you're closer to wrapping up.
No, I'm not. So would you agree with this sentiment, which was expressed by the Constitutional Court, or not? We may criticize the public protector for failing to realize that the legal point she was obviously advised to advance was a non-starter, but can we really go far with that criticism? I think not. She got advice from senior counsel. Of importance, we do not know whether the public protector has any experience in civil legal practice, and the commissioner did not suggest that she does. That for me is the end of the matter. Would you generally agree with that sentiment? That if she got senior advice, in this case, even from senior counsel, then that should be the end of the matter.
Thank you. Just before you respond, Mr. Ebrahim, Advocate Mayosi.
I think they anticipated my question, which was similar. If we could have just the citation so that we can put it up if we can find it.
Oh, yeah,
And
no,
which
that
case
one
it
is, yeah, it's Commissioner for SARS versus Public Protector. 2022, Volume 1, 370 Constitutional Court cases. I think paragraph, I was reading from paragraph 50.
Is that the minority judgment of Judge Mkhweng, Chief Justice
No,
Mkhweng?
it's the unanimous majority judgment of Matlanga.
That's the other one. Okay.
Thank you.
Yes.
Mr. Ebrahim?
I thought we were waiting for the judgment to come up. Are they drawing it up?
Okay.
Are they going to, so that one
You
can
heard
read
what
it?
I said.
You're asking me to apply my mind to
Yeah,
to
okay.
the statement.
Now we'll
haven't seen
flag it.
I'm worried about
In the meantime,
Honorable
while we're
Mulder.
waiting for that,
Time.
may I assist you with one point, which is that in the rules, what the rules do is that with regard to the question of legal lack of knowledge and so on, the definition of incompetence is as follows in terms of the rules. It says it's concerned with both a lack of knowledge and ability or skill to discharge the functions of the office.
Are you talking to me?
Yes, sir.
What question are you answering? I didn't ask you.
Sorry, just
You had-
pause, please.
Ask the question.
Mr. Ebrahim,
Yes,
you're talking through the chair.
my apologies.
You're not talking
Chairperson.
to him, and he's responding to your question, Advocate Mpofu. And I don't appreciate that kind of line of questioning that you're doing. He's responding to a question that you're putting to him. So when he responds, I don't know why you would come with such a reaction to his responses.
The person, what question? Which question was
You've
that?
just asked him whether he's talking to you. And I'm correcting you now. Whatever that you do next, you're going to be speaking through the chair.
Correct.
As questions are posed to you. Please proceed.
Chairperson, what I was merely referring to, the Advocate Mpofu asked the question with regard to legal advice and what to do with it. I was merely referring to the rules which define incompetence. And I merely state it as it is, because the rules have defined incompetence in the removal rules, and which is concerned with the duties of the public protector, by saying it's concerned with both the lack of knowledge and the ability or skill to discharge the functions of office. I'm merely stating what the rules say.
Oh, I thought you were putting up the paragraph. Now, can you answer my question?
Yes, sir.
Which is, do you agree with the sentiment expressed by Matlanga J that if the public protector has accepted legal advice from senior counsel, that should be the end of the matter?
I'm not sure the end of the matter meaning what, but the public protector is entitled to receive whatever advice the public protector gets. Whether the public protector is responsible for that advice is quite a different story.
No, sir. Okay, I'll read it again. I'm talking about criticizing or blaming the public protector. It says, we may criticize the public protector for failing to realize that the legal point she was obviously advised to advance was a non-starter. But can we really go far with that criticism? In other words, will that criticism be valid? Yeah. I think not. She got the advice from senior counsel. Of importance, we do not know whether the public protector has any experience in civil legal practice. The commissioner did not suggest that she does. For me, that is the end of the matter. Do you agree with that sentiment? I'm not saying not every word or every comma, but with the sentiment expressed by the Constitutional Court, or do you differ with the Constitutional Court?
I'll actually differ with that. I have a different view.
Thank you. And if we had to choose, you would agree that we would have to choose the view of the unanimous Constitutional Court?
There's no question that the court's decision is binding. You asked me a different question. You asked me whether I agreed with the sentiment. I said, I don't agree with the sentiment.
Yes, I'm asking you a different thing now. I don't know why you're going back to the previous question. I'm saying, do you agree that since you don't agree, the committee should prefer the view of the unanimous Constitutional Court to that of you or me?
Without a question.
Thank you.
Let's see.
Putting it up, but I think it would have been fair for Mr. Mpofu, Advocate Mpofu, to put the entire paragraph 50 to the witness.
Okay, good. I could even do the entire judgment. Okay. No, to put it up, yeah. No, that's fine. I have no problem. I'll read the
Honorable Luzipo, Lotrit and Mola.
Yeah.
That order. No, Chair, I just on a point of procedure. Once dealt with a matter referred to us. Now, as a committee of parliament, we were told that we have got no right to make an opinion on a matter that is on another arm of state. In this case, the constitutionality or non-constitutionality cannot be subjected to a legislature. Now, I'm just worried about one thing that I just want to check probably with the Advocate Mpofu. Is it what was referring to a judgment of the court
And if it is a judgment of the court, what become a recourse of this committee in expressing opinion on a judgment of another arm of state, which is the judiciary? I'm just doing it for the sake of the committee. Maybe we can get an advice. But I fear a situation where we may end up making, because if it is expressed here, it means we may also have to develop an attitude on what has been raised. And will it be fair for a committee, a separate arm of state, to agree or disagree, or get a view that agrees or disagrees with a judicial outcome? I think that's the only area I would need clarity, so that we don't sound like we ended up encroaching on an area that is not ours. Constitutionality or non-constitutionality, we're told clearly that's not a parameter for a legislature. I think that's the issue I wanted to check.
Okay.
Thank you, Honorable Luzipo. I'll quickly go to you and go to Honorable Lotrit and Mola.
Yes, thank you, Chair. Yes, very quickly. Thank you, Honorable Luzipo. I think that there are three quick issues that are raised by what you're saying. The first one is the sentiment that was raised by the evidence leaders yesterday, which you'll remember I disagreed with, where she said court judgments are binding on the committee. And I said that in the context that the committee cannot be bound in the same way as a court. But obviously, a court judgment is a court judgment. It's there, you can't ignore it. So that's the first level. The second level is that the committee is not called upon to express any opinion on those judgments. And actually, the issue you're raising is very serious because it goes to the core of why we're here. You'll remember, if you read the independent panel report, that there's only one charge to do with a Mr. Samuel that is not based on a court judgment. So the whole thing that has brought us here is based on court judgments. So there is that issue. Then the third issue, which is even a more serious issue, is the issue of sub judice, which I think is what you're alluding to as well. And I must confess, I'm also worried about that, because the issue of, for example, not on this thing that we're discussing now, but on all these other issues about the starting and not starting and the existence of the ground and so on. We all know, I reported here yesterday that those issues are going to be debated in court on the 25th and 26th. So I think that concern can only be in that third category. The first two, I think, were fine. But as to whether the issues about this committee continuing when the matter is coming in 2 weeks' time on the interpretation and the conflict and all that, that's not my area. That's something for the committee.
Honorable Lotrit.
Yes. Thank you very much, Chairperson. I am very concerned because it has happened quite a few times now that reference is made to specific judgments and only paragraphs. This puts this committee at a distinct disadvantage because we do not have the context, because it is easy to cite from a particular judgment, but we don't know what the whole case was about. So up to now, this morning, Mr. Ebrahim focused on a document that we were presented with earlier. We could prepare, but now new cases are being mentioned. And I quite frankly feel very disenfranchised here that I cannot assess it and I cannot take the most out of whatever Advocate Mpofu is saying. Thank you.
Chair, can I respond to that?
Just hold. Honorable Mola.
Thanks, Chair. No, mine is on a different angle. Mr. Mpofu started with cross-examination before the lunch time. Went to lunch. The time now is about 3:45 p.m. After the cross-examination, you still have about 20 members of parliament who must equally be afforded time to cross-examination the witness on stand. I'm not sure, Chair, if we are prepared to overlap the program, but it looks like we are moving at a stale pace that may delay and cause the committee to overlap the program. So Chair, I just wanted to awaken you on the issue of time management, and although you must balance it with allowing the fair chance to everyone to cross-examine the witness on stand, but I think we must equally be conscious of the time we take when we are processing the cross-examination. Thank you very much. It's just that.
Thank you. I think both yourself, Honorable Lordship, the issues you're raising require my response to it, which I will do. Advocate Mbofu, I had indicated earlier that I'm urging you to wrap up your questions to Mr. Ebrahim, because there's going to be an...
Yeah, well, thank you, Chair. No, Chair, I can't wrap up without covering the areas that he covered in his 70-page document, which affect that's what cross-examination is.
So sorry, don't go there.
Yeah.
So what are you talking about in terms of areas? Because at least by 4, I'm expecting that would have wrapped up with your questions. If there are going to be questions that you would not have been able to pose, a time can be rearranged later on at another time, because from tomorrow, in terms of the program that you yourself have seen, we've got witnesses that have been lined up, and we are still going to meet as a committee to deal with the issues of directives and so on. So I'm urging you to please prioritize what you want to put forward.
Yes. No, thank you, Chair. No, I misunderstood you. When you say wrap up, I thought you meant I must finish. But if I don't finish at 4, I don't finish. Then we'll make the arrangement you're talking about.
Chair, Chair?
I'm saying, Chair.
Just before you proceed, Honorable Melder and then Honorable Maute on the platform.
Okay.
I just need us to come back to the paragraph that Advocate Darlene Porfer referred to, and I just want to make sure which one he referred to and where we have the full paragraph.
Yeah, no, I'm coming to that. Actually, I wanted to say to Honorable, Lordship, that this case is actually not a new case. It was referred to by Mr. Ebrahim in his document.
Please just hold. Honorable Maute.
No, thank you very much, Chair. I've been listening to my learned colleagues, and I think we want
It's this, if you go to, for example, I don't see where, I'm sorry.
Just hold. Honorable Maute.
Yes, I'm saying I've been listening to my...
We can't hear you. Your voice is low.
Can you hear me now, Chair? I'm a loud person by nature, so I don't know. Maybe it's your mics that side. Can you hear me, Chair?
A bit louder. We can't. We're struggling to hear you.
On the left, you can hear. You can hear.
Yeah.
Yes.
I'm very loud, Chair. I think it's your speakers that side.
Okay, we can hear you now. It went too much, but we now can hear you.
Okay. No, I was saying, thank you, Chair. I've been listening to my learned colleagues, and I don't want us to find ourselves in a situation where we want to deny Advocate Mbofu the opportunity to cross-examine Mr. Ebrahim. He had the whole time in the morning, he was not interrupted, but I've seen a lot of impatience now that Advocate Mbofu is asking. Maybe he's asking difficult questions and uncomfortable questions, but that's why we're here. And also, Chair, we can't be guided by 4 o'clock. What informs the 4 o'clock? If we have to sit until in the morning, in the early hours, so be it, but let's allow him the fair chance and the fair trial. I don't agree that we should no, if we don't finish after 4, we'll sit and I'm saying we are members of parliament. We agreed to be part of this committee. This committee cannot be dictated to by time, by 4 o'clock or by 5 o'clock. If it means that we have to sit, let us sit. But let's allow Advocate Mpofu to ask questions. It doesn't matter how uncomfortable they are. And the people that come here to witness or to speak here, they must know that they're going to be asked uncomfortable questions. We're not here really to nurse anybody's feelings, but to assist this committee to come to a conclusion of whether there is any grounds for anything on the public protector. So I think let's play fair, including yourself, Chair. Be patient with the advocate. He's a learned advocate, very bright. Let's give him.
Thank you, Honorable Maute. Thank you. I've already indicated to Advocate Mpofu that expect him to wrap up by 4. If there are going to be outstanding questions, we will relook into that. I've already indicated that. Please don't take us back. Advocate Mpofu.
Chair, I'm saying going forward, what informs the 4 o'clock? That's my question. As a committee member, what informs?
I have not recognized you, Honorable Maute. And you are not going to, and you are not going to repeat that. I have not recognized you.
I'm repeating.
You are not going to repeat that.
I'm repeating. I'm repeating, Chair.
Honorable Maute, I want you to stop.
No, don't try me.
You are not going to have a dialogue with me, Honorable Maute.
Answer my question. What informs the 4 o'clock?
Honorable Maute, you're not going to have a dialogue, and I'm not going to continue doing this. Honorable Mananiso.
Answer my question.
Thank you, Chairperson. One wants to indicate that there's a program before us. And whatever that is happening today, it happened yesterday, where we were confining ourselves between 10 o'clock to 5 o'clock. So Honorable Mante must not be opportunistic. So I would want to just remind members to confine themselves within the timetable that we have before us. Thank you.
Thank you, Honorable Manani. So, Honorable Maute, I'm warning you. Thank you, Honorable Suela.
Chairperson,
Honorable Suela.
Chairperson, I'm covered by the latter speaker that let us stick to our program. I believe we have agreed with Advocate Mpofu, and he has also agreed that we really want him to do his work, but at the same time, we must respect our program. We have adopted it. Thank you.
Thank you, Honorable Suela. Advocate Mpofu.
Thank you. No, thank you. I think maybe the confusion is that the program says 5 o'clock. Yeah. So I think but it's fine. I've agreed already, as you say, with the chair. I don't care what the reason is. If he wants to stop his committee at 4, we'll stop at 4. And then we'll do whatever we have to do at another time. If he wants to stop now or at 5 or at 8, it's not my place to determine. But my place is simply to tell the chair, as I have done, that I still have other things to cover. And I think we'll make arrangements. I thought this witness, subject to what Ms. Power has to say, because I was chatting to him at break, I thought he was available to roll over until tomorrow. But that's something that can be arranged maybe with the witness. But I won't ask a single question 1 minute after 4, even if I'm in the middle of a question. All right. Now, you've also testified about powers must be exercised without fear. Let's just stay there. Let's forget about the favor and prejudice. You agree with that?
That's correct, yeah.
And the fear that is spoken about when we say that the public protector's mandate must be carried out without fear, favor or prejudice, with the emphasis on fear. What might that fear, where might it emanate from? Or let me ask it as a leading question. Would you agree that it would most likely come from those that she's investigating?
I think that has been cited very clearly by the courts in all the documentation. So in the certification court, which is why in the certification judgment, which is why the court required a supermajority for the removal, because the public protector takes decisions regarding the executive and those in power that may be affected. So yeah, there should be no fear that.
Yes. And you're right. And in the EFF Nkandla case, Justice Mogoeng went further by describing her as the biblical David who has to fight the Goliath, and also to investigate even those at the raw chambers of power or rooms of power. In other words, the most powerful in society, including the president.
There's no question about that.
Yeah. And you would agree that therefore part of the protection that is required for the public protector would be if she is investigating those powerful persons, such as the president, who might have be able to wield an axe on her, metaphorically speaking. You'd agree?
The only authority that could wield an axe is the National Assembly, because the public protector is accountable to the National Assembly. So it's only from the National Assembly that there could be a wielding of an axe. It requires a National Assembly with the 2/3 majority to declare that. So nobody else can wield an axe.
Okay. Were you in the country on the 9th of June, 2022?
Yes.
Okay. Are you aware that the president on that date suspended the public protector?
Yeah.
You are?
Yeah.
Okay. All right. So would you say that those persons that she is investigating who might have the capacity to mete out punitive measures against her would include those from whom such fear must be, or rather from whom she must be protected?
No.
No.
I don't agree with you.
Okay. So she must not be protected from those she's investigating.
That's not what I'm saying. I said I didn't agree with you.
Yes. No, you don't have to argue, Mr. Ebrahim. I'm simply trying to rephrase the question so that I can understand it. If you want to argue with me, let's not do it here. Yeah.
No.
I'm saying, you dispute my statement that those persons from whom she must be protected and from whom she might have reason to fear would include persons that she's investigating who have the capacity to cause her damage.
The public protector, the chairperson, the public protector is entitled to protection against anybody and everybody, and should be allowed to undertake the course of her activities and responsibilities. That does not preclude, however, any other authority taking action against the public protector, provided it is within the course of the law. There's nothing wrong with that.
Okay, I don't think we're going to make the 4 o'clock deadline. You're not answering my question. I'm asking you on the basis of the known facts, right? Firstly, I agree with you that the public protector is accountable to the National Assembly.
Yes.
But here we have a unique, very unique constitutional situation. You have said correctly again earlier on that the public protector is answerable exclusively to the National Assembly. Is that correct?
That's correct, yes.
Yes. You have also said that ordinarily there should be no encroachment of the executive into that domain. Agreed?
Correct.
Yes. But you see, this is the issue here. I don't think it's appreciated. One of the members said this thing is simple yesterday, but That's the furthest thing from being simple. Now, given that scenario of exclusive accountability to the National Assembly, the need to prevent any encroachment by the executive, we have something called Section 194.3a, which does the exact opposite at face value. Because it gives, you agree that Section 194 is what is called by the Constitutional Court the ultimate accountability mechanism. Agreed?
Yeah.
Like Section 89.
Yeah.
Yes. Now, in that ultimate accounting mechanism, the constitutional writers introduce a member of the executive called the president. Okay? Yes. And that's why this idea that the two things have nothing to do with each other beats me. So we have a situation where the constitutional writers say, in the middle of this ultimate accountability mechanism, the president, who's a member of the executive, may suspend, in other words, may cause some damage to the, I'm using that term loosely, to the public protector. You understand that that brings, well, as a constitutional scholar at least, or a constitutional maker, you understand that that's a unique set of circumstances.
Yes, you are conflating again two things. One is the person, and second is the office. If there was an inquiry by the public protector against anybody, that inquiry does not die, it's only because there's been a suspension or whatever. The work carries on.
So it carries on how?
The public protector exists, functions, and the public protector is entitled to proceed with whatever activities it is proceeding with.
Yes, but
we're separating the person.
Oh, I'm sorry, but there's one public protector in South Africa.
Yes.
And that person is Advocate Mkhwebane. Do you agree?
Yes.
Do you agree?
Once action that any action against the president or whoever it is does not die because of the suspension. You cannot equate the two because the office still is open. The office still exists. So the functioning of the public protector is continuing. So if there were legal matters, investigations that were being undertaken by the public protector, it's got nothing to do with the suspension. We are conflating the two inappropriately.
Well, okay. Firstly,
the office exists, Chairperson.
Okay. Firstly, you're answering a question I've not come to yet. I'm coming to it, so you can relax. I've asked you a very simpler question. Do you agree that we have a unique circumstance where in the midst of the so-called ultimate accountability mechanism, in the face of the fact that the Constitution says the public protector accounts to the National Assembly, but the Constitution has introduced a member of the executive in that process to do a suspension. That's all really. I don't know what you're talking about. We're coming to these things about whether in the office and what happens and so on. Just answer my question, if you may.
I'm not sure if I understand your question. I really cannot understand your question at all.
Okay, I'll simplify it even further, and that will be my last attempt. You and I earlier agreed that what triggers a suspension is whether the process, or rather the removal proceedings have started, correct?
Yeah.
Pardon?
Yes, yes, sir.
Yes. Now, I'm saying that intersection between the activities of the inquiry and the activities of the president, both of which belong to two separate arms of the state.
Correct.
is a unique conflation of the accountability mechanism where there's an introduction of the executive. I mean, surely that must be clear.
No, I don't agree with your argument.
Okay, do you know that the president is a member of the executive?
Correct.
Yeah.
Head of the executive.
And this committee is made up of members of the legislature.
That's correct, Chairperson.
Right. Now, section 194.3a mentions both in one breath.
Yes.
Okay. Yes?
Yes, sir.
Yeah. So now I'm saying if the two separate terms we should theoretically stay apart are mentioned in the same sentence, in the same breath, in a particular section of the Constitution, the one basically triggering for the other to act. You don't think that that is a unique situation under the topic of separation of powers?
No.
Oh, yes. Okay, fine.
Recording stopped.
Oh, yes. Yes. Quite long.
Thank you, colleagues. As I indicated, I think now let's resume. I would want to have a quick interaction by members with the witness, any issues that you would have picked up, listening to the presentation. Immediately after that, to have our brief session on the directives. If members and the evidence leader and the team led by Advocate Mpofu, after that, would still want to squeeze out a few more questions, I will allow that. So let me note and recognize any member who wants to comment or pose questions to Mr. Ebrahim. Honorable Mahlaule
Chairperson, I'm sorry, honorable members. I just want to indicate, I'm not finished with my cross-examination. I just stopped because you said we must stop at 4.
Yes.
Oh, you understand? Okay.
I understand.
No, I'm sorry.
That's why I said I'll come
Recording
back.
in progress.
Thank you.
Yeah.
Thank you.
Thank you.
Okay. Thank you. Sorry for that.
Honorable Mahlaule, Honorable Hassen, Honorable Milham, Laudridge, Ngola, Hendricks,
Imam.
Mkulua. And then I have Mananiso, Sheikh Imam, Luzipo, Shlakode, and Maneli. As I give to you, and this is something we'll speak about when we start the directives, you know the rules which are applicable here. Honorable Mahlaule.
Thank you very much, Chair. Greetings, Mr. Ebrahim. Chair, there has been a discussion around the distinction between a person and the institution called the public protector. Now, when you turn to page 26, paragraph 37.3, you read through the bolded sentence, you go to the second one, and when you get to the third one that says, for this reason, the fathers and mothers of our Constitution conceived of a way to give even to the poor and marginalized a voice, and teeth that would bite corruption and abuse excruciatingly. And that is the public protector. Now, what follows there is has. Is there a particular reason why you used has? And the reason I'm asking that, I want to understand what you're talking about when you speak about the public protector. Are you talking about the person or the institution? In other words, I want you to expand on the issue of a person and the office. And that would be linked with a paragraph in page 37, paragraph 53. That says, at all times, the public protector must not put personal interest over and above the public interest, and not put personal interest above those of the office of the public protector and the mandates of such office. What is the distinction between those interests? Are they the same? Are they the same interest? That of a person and that of the public protector? And what makes me ask this question would be another point you made. I think it's page 60, if I'm not mistaken. I'll quickly just give me a moment. Yeah, it's page 54. On the heading, it's paragraph 89. The heading on a particular individual's incumbency must be separated from the constitutional office. In your view, you said you can even take it further to say it is very important actually to protect the office from the incumbent. If you expand that, it will assist us to understand your understanding of the distinction between a person and the office. And while you are on that, please express yourself on what is the logic in this regard of the courts when they order costs, to say this is a cost to the person of the public protector and sometimes the office of the protector. In your view, and I appreciate that you're not in court here, just give us your personal opinion. In page 52.
Is that your last question?
Well, I can make it the last question if you so wish, Chair. But,
thank you, Honorable Mashaule.
Yeah.
Mr. Ebrahim.
Okay, then let me go to page 60 if
Okay.
that's the last question, Chair. Paragraph 95.5, which speaks of the requirement of effectiveness and efficiency. And it outlines certain measures. And it says the requirement of efficiency, I'm taking the sentence number 2. The requirement of efficiency requires conduct to be measured against the extent of resources it required, have the resources of her office, again, the use of her and his, and then in brackets, it says time, personnel, money, being reasonably deployed to achieve the public protector's mandate. Both requirements necessitate a consideration of the outcomes of the public protector's conduct. Now, Advocate Mpofu yesterday said the public protector achieved 2 clean audits. And it has become a norm that in South Africa, when you achieve a clean audit, we say you are efficient and your office is effective. Would you agree in that context that this is the case in the office of the public protector? Thank you very much.
Mr. Ebrahim.
Chairperson, there was quite a few questions packed in that. Primarily, the first few questions, I think, were related to the distinction between the office and the person. Essentially, I think in most instances, we conflate, we speak about the person and the office in the same breath. Properly speaking, and proper drafting would require us to use gender-neutral terms when referring to a public protector. So as not to stipulate one gender or another. Because we must separate the person from the office. Because office does not end with the public, with the person. In between, when there's a change of office, after one term is over and another term starts, reports continue, work continues, the office continues. The office does not come to an end. So the office should not be conflated or confused with the person themselves. And so I think we must be quite clear. And the way in which the judgment was drafted merely referred to the person. I think in some instances, judgments and legislation could more profitably be referred to in gender neutral terms rather than referring to them in a particular term. Now, the question of efficiency versus effectiveness, I think that it's a fairly important question. The effectiveness is really the ability to actually act in a way in which to deliver on one's strategic objectives, whereas efficiency really deals with the question, the way in which one deals with financial efficiency, the resources. So those are two distinct and separate issues. When it comes to an audit is an audit. It merely suggests that money was well spent. It doesn't necessarily suggest that money was spent on the right things. It says that the money was spent in terms of the PFMA, and depending on the scope of the audit, that will determine really what the nature of the audit is. So the fact that an institution, any institution receives a clean audit is dependent on the scope of the audit that is undertaken right at the beginning. Based on that scope, the Auditor General carries out an audit, and if the audit is clean, it's a clean audit. It means that money was spent in terms of what was required. But for me, it's a happy occasion. It's a happy occasion, and one must be respected. I hope I've sort of.
Thank you, Mr. Ebrahim. Mr. Hassen.
Thank you, Chair. I have questions for Mr. Ebrahim and for Mr. Mpofu, and so I don't really know how to proceed.
You just pause for Mr. Ebrahim now. And I'll come back to with Mr. Mpofu when he takes the stand.
Thank you. No, not when he takes. I'm sorry.
We will hold back the ones for Mr. Mpofu.
Okay, thank you. Just briefly, Mr. Ebrahim, you set out quite a lot of detail what a fit and proper appointment as public protector would be. And then you have a checklist of about 47 items that the committee could consider. But I just want to be clear that the grounds for appointment, which includes being a fit and proper person, are not really related to the grounds for removal, which must be either misconduct, incompetence, or incapacity.
Yes.
So I wanted to be clear that the long explanation about a fit and proper person, I'm just wondering what relevance it has in terms of misconduct, incapacity, or incompetence. My second question relates to the expansion of the powers to expand an investigation, and you refer in paragraph 68.4 to that as something that the public protector cannot do, but that relates in your document to the Executive Ethics Code and the a breach of the Executive Ethics Act. How does that sort of align with some of the other positions or submissions you made around seeking out the truth, that the truth has to be discovered, as you say in paragraph 61, that the report must be accurate, the report must be meaningful and reliable. I think you also, you cited a nice paragraph about what an open mind means. And if you're an investigator and you're pursuing something and the pieces don't fit, you keep going until they eventually do make sense, doesn't that require you to expand the investigation if that's where the investigation leads you to? So the rule around expanding the investigation, is that confined to the Executive Ethics Code, or is it, even in the Executive Ethics Code, can it be expanded if the truth takes you somewhere? Yeah. And then I'm struggling to understand your position on the predetermination process, where you say that the predetermination process is making out the words that define what misconduct is. I would imagine that a predetermination would be finding that there's a prima facie case to be answered, and that would require some sort of inquiry process. So I'm wondering how you see the role of the independent panel that conducted a documentary inquiry and then presented this committee or the National Assembly with a recommendation that there was a prima facie case to be made out, and whether that couldn't constitute a predetermination. Thank you, Chair.
Thank you, Honorable Hassen. Mr. Ebrahim.
Chairperson, thank you very much. I think the first question of fit and proper is fairly basic. I think what a generic requirement in the Constitution and most constitutions for the appointment of legal officers is that the person must be fit and proper. You'll find it in all pieces of legislation. It's not just in our jurisdiction, it's in all jurisdictions. But a fit and proper person and the beauty of what has taken place arising out of the litigation that has taken place is that the courts have been asked to apply its mind to different aspects and facets of what is fit and proper. And the jurisprudence is very useful in defining and delving into a proper definition of fit and proper. But that's quite a separate issue from the question of the removal. Now, you refer to the end and the long list that I've provided. What I think is of value here is that, and what was hoped was that coming out of this committee's work, this committee would have access to a set of requirements based on constitution, legislation, rules, and jurisprudence of really what are the requirements of a public protector. So hence you find a long list of 40 odd issues. And that comes out of all of the items, whether it be constitution, legislation, or jurisprudence. It's merely a guide. So my own view is that it provides a National Assembly with a kind of a checklist, not in terms of both should you need to appoint a new public protector, you now have a very clear understanding of what type of conduct you want and what type of a person you are looking for, but also in terms of monitoring. So it provides you with that knowledge. It's just basically a knowledge management exercise. The question of expansion of the investigation, it's not a fait accompli in the sense that an expansion, an investigation can be expanded with lawful justification. If there's lawful justification, remember that the court spoke about an open mind. So where you have an open mind and you're undertaking an investigation and it leads you to further issues, then those are issues that you are required to apply your mind to. And that's what the judgment said when it looked at the question of an open mind. On the question of predetermination, my understanding was that in the context that we were talking about, quite aside from what the independent panel spoke about and quite aside from the other issues that were referred to, the predetermination related to the requirements that were identified or the grounds that were identified in the Constitution did not have definitions. And therefore you could not proceed. You could not start an inquiry and in the inquiry try to define what misconduct was. You had to predetermine that. And it had to take place before the inquiry started. And hence the National Assembly went ahead and produced a set of rules which then defined the question of what those grounds were. So it gave meaning and depth to what the Constitution identified as the grounds for the removal. I hope I've sort of tried to cover as many. I hope, Chairperson, I hope I've covered it all. If I have, then I'm happy to
Thank you, Mr. Ebrahim. Honorable Lutford.
Thank you, Chairperson. I'm not going to again ask about the differentiation between person and institution. I think that question has been asked. Mr. Ebrahim, what I would like to know, let me just get to that page. You did earlier in your submission point to, and also on reply to Advocate Mpofu, about the comparison between a judge and the public protector. In para 40, you do state the appointment of the public protector is also materially different from the appointment of judicial officers. Would that form part of your interpretation of whether this comparison between the public protector and judges, that it is not the same? Would that be part of that? And then secondly, I'll just get my notes here. This is about liability and who takes ultimate responsibility, because this matter was also raised yesterday. If I am correct, I think it is paragraph 79, that you actually refer to that the public protector takes ultimate responsibility for decisions. Would that be an all-encompassing responsibility, of responsibility, or would that be limited in certain extents? And then lastly, in the 47 points you made to take into consideration, at 100.44, you refer to the expansion of an investigation, that it may not be expanded without lawful justification. However, in your submission, you refer to narrowing of an investigation to the extent that it becomes meaningless. Is there a specific reason why that is not included within the 47 points? Thank you.
Thank you, Honorable Lordship. Mr. Ebrahim.
Chairperson, if I start with the last one first, because it's the easiest. The matter, what I raised and identified came out of jurisprudence and debate and legislation and the Constitution. But in as much as the expansion is possible with lawful justification, I would imagine so would the narrowing be possible with lawful justification. There's no reason why it shouldn't be. You raised a whole host of issues. I hope I'm actually going to pick up on each one properly. Yes, the public protector in the hierarchy of things in terms of the office does assume final responsibility for decisions that are taken, because that's the function and the role of the public protector, in the sense that the law vests authority in the office of the public protector. And so the incumbent is required to then apply their minds to the requirements, and that's the decision that they will take. So I assume that will be so. In terms of the question of liability, liability is generally, where there's liability on the public protector in general, it would be for the office. In general, where there's office, the public protector attracts liability, it would be the responsibility of office to settle it. However, the courts applied its mind to something quite different. It applied its mind to areas where the court found that there were a series of errors of judgment, mistakes, and incompetence, and for various reasons found there was a basis on which the judgments or a cost order could be accorded not just to the office but to the person themselves. It's more punitive measure and something that the courts had adopted. The question of judges versus public protector, I'm not sure whether that's a fruitful sort of investigation to pursue. Both the public protector and judges occupy a space within the administration of justice, except for the fact that judges occupy the space which deals with law and conduct. The public protector occupies space in administration of justice when it comes to public service, which may be related to finance or any other conduct, bad service, capricious activity, and in its broader aspect. And it's part of administration of justice because people are aggrieved by the conduct of some organ of state and therefore seeks redress. And so the public protector provides it. But insofar as what public protector can do in some instances is remedial action, negotiation, mediation, and so on. Those are matters which judges and courts don't often do. They often stop at a point at which deciding on a case based on the law, premised on procedure, very strict procedure and so on, and they will issue an order of court, and that's the end of it. They would not per se deal with remedial action or negotiation or find methods in which to find redress. So I think that the two are quite different offices, but occupying broadly the same space within administration of justice. That's what I would argue. I hope I sort of broadly covered you.
Thank you. Honorable Mayham.
Thank you, Chairperson. Mr. Ebrahim, I just want to take you to section 194 of the Constitution. There are two references to a committee in that section. The first is section 194(1)(b). It requires a finding of the committee. Is this committee the committee that would generate that finding? Secondly, with regard to section 194(3)(a), where it talks about a committee for the removal, again, is this the committee that is referred to in that section? Noting that this committee has no removal power, that decision ultimately rests with the National Assembly and the President. So my question in both of those cases is this committee, first in 194(1)(b) and secondly in 194(3)(a), the committee that is referred to there? Then just picking up on what Honorable Lotrit and Honorable Heron spoke about, we heard yesterday, and I'm going to dig a little bit deeper into it. We heard yesterday, and I'm paraphrasing here, Advocate Mpofu, that the public protector was not involved in all the investigations and thus could not be held personally responsible for any failures that might arise in those investigations, particularly with regard to, and we heard again today, that if she takes legal advice, she can't be held responsible for incorrect legal advice. Do you agree with that sentiment? And if so, could you expand on why you agree with that sentiment? And then...
Maybe you're done.
No, Chair, just one last one. I guess it goes back to, and I don't really want to open up a whole new can of worms here, but I feel that we need to close this matter conclusively. You spoke about the predetermination. You spoke about in fact, Advocate Mpofu spoke about the need for, his words, a determination that the misconduct or the incapacity actually exists on the part of the person before there can be an inquiry. Now, and this goes, I think, to what Honorable Heron was trying to get to. There are a couple of different events that have happened. The first was the rules were drafted on the 3rd of December 2019, and they were accepted, and that then defines what misconduct and incompetence look like. We then move forward to the independent panel, which then makes a finding that there is prima facie misconduct and or incompetence. And then we move forward from there to this committee, which is now taking evidence and hearing various points of view around the matter. My question is, at what point does the removal process start? In other words, is the removal process when the motion is tabled in Parliament? Is the removal process when the independent panel commences its work? Is it when it concludes its work? Is it when this committee is established? Is it when this committee concludes its work? Is it when it's tabled in Parliament, in the National Assembly? So I'm trying to figure out, in your mind, at what point in that continuum where the start point of the removal process is. Thank you, Chair. That's all I wanted to ask.
Thank you, Honorable Ebrahim, Honorable Olomisa. Angwamkolo, Fununga, Honorable Hendricks.
Thank you very much, Honorable Chair. We heard an expert view that when we exercise, for example, our votes, it must be in the interest of the institution and we don't follow the party line and we don't fear that the caucus will discipline us. And secondly, we won't pop champagne corks. So that was a clear message. Do you still stand by that position? Because that is going to guide us going forward, that honorable members must act without fear and favor and think of the institution and not their political party. Sorry that members will lose out on champagne, but I think you need to send a very clear message to the nation as far as this is concerned. Then lastly, Honorable Chair, the Advocate Bauer made a very strong point that the office of the public protector is to serve the poorest of the poor. It is my view, after listening to the Roman law, the Dutch law, the British colonial law, the Latin words, Advocate Bauer, after this whole process is completed, I would like to put to the expert, is that a pipe dream and the end of the Chapter 9 institution in terms of its original inclusion in our constitution? Thank you very much.
Thank you, Honorable Hendricks, on that champagne note.
Chairperson, I start with the last point first because I think that's really appropriate. Parliament is the voice of the people, and the Constitutional Assembly, the constitution makers developed or established institutions that they believed would serve the interest of the poor. The world is in agreement with the perspective adopted by this Constitutional Assembly. I can assure you of that because I work in the international community. Many countries are emulating the approach, watching very carefully what you do and the decisions you take. So it's being observed with great interest throughout the world and admired and respected, only because there's nothing to compare. And South Africa had undertaken an approach which the world believes is the appropriate approach. And people believe in the function of a public protector. And certainly it's being adopted by many countries in their own constitution. So the answer is no, it's not a pipe dream. But I don't believe that in as much as 1994 did not yield the fruits of the Freedom Charter or whatever else, it is still something that we would like to follow a dream and a hope that we'd like to pursue. So with the public protector and serving the interests of the poorest of the poor will be an ongoing exercise until hopefully there won't be poor to serve. But yes, it's still a viable function, and the world is in agreement, supportive and respectful of what you're doing. On the question of the political party, the issue of dealing with the approach of an important institution like the public protector is not an ideological issue. It is not a party political issue. It is an institutional issue because the public protector is a creation of the Constitution and therefore objectively occupies a role and a space in our body politic that must be respected and appreciated. It doesn't come out of an ideological set of ideas. So when Parliament deals with whether it is appointment or removal, then I believe Parliament deals with the matter in terms of what is in the best interest of people, not in the interest of your party political perspective. So when this committee applies its mind, it should apply its mind not on the strength of party political perspective, but in terms of really what is it that is in the best interest. If I may move on. Honorable Milham, I think there's a number of points you have raised, and I hope I've actually got them all. The first point you raised is on the question of 194. The issue you raise is at what point does the work start of the removal, and the committee, and it does start with the establishment of the committee referred to in 194(1)(b), and that's a committee that makes the finding to the effect that there needs to be the removal. But the establishment of the committee is the start of the process, the formal start of the process. The fact that you have applied rules, those are normal matters that the National Assembly would have to apply its mind to as part of its predetermination. So it would fathom out as to what are the definitions and details for the removal process, but that's an objective set. The establishment committee is very specific, so I think those are important. The question of investigations and I forget now the perspective you referred to, investigations and the person of the, is it the person of the public protector?
Just repeat that question, Honorable Myla,
please.
Thank you, Chairperson. My question was, and it related specifically to that the public protector was not involved in all investigations personally, and that, and this was the suggestion that was put forward, and thus could not be held responsible for the for any failures that might arise from those investigations. And then I went one step further and said, if the public protector receives bad legal advice and reports that bad legal advice, could the person of the public protector be held responsible for that bad legal advice?
The first part of your question is fairly clear, because an investigation undertaken by the Office of the Public Protector doesn't necessarily have to be personally. Public Protector cannot deal with each and every of the many cases that they undertake. So the Public Protector is very much an office and an institution that has loads and loads of cases that they will deal with. So the Public Protector personally cannot assume responsibility for each and every case. However, those cases must be undertaken under the auspices of the public protector, and therefore the public protector is the person who will come to Parliament and say, I've undertaken so many cases. It doesn't mean that the public protector has dealt with each and every case individually and can answer to each and every case. But essentially the report of the office is done under the auspices of the public protector, and therefore it's regarded as the public protector. The question of legal advice is quite a different story. The public protector seeks support from different service providers, whether it be on legal advice or any other supply chain or whatever it is. At the end of the day, it's a question of what particular aspect, how one deals with the implications of the legal advice, and to what extent the public protector can assume responsibility for it. So I don't believe that one can, in one brush stroke, suggest that either the public protector is totally responsible or totally not responsible, but I do believe that the Office of the Public Protector assumes responsibility for whatever decisions the public protector takes. And one would have to actually delve into really the facts of it as such. Cover you.
Thank you, Honorable Ebrahim. Honorable Zungula from the virtual.
Thank you, Chairperson. I think the first would be to make a follow-up, maybe to ask the advocate whether the issue of Parliament taking a resolution to establish a committee.
On a point of order, Chair.
Just pause, Honorable Zungula.
Chair, when Honorable Heron wanted to direct a question to Advocate Mbofu, you said he must reserve it. So you are going to get back to them. Now, I am raising an order, Chair, that Honorable Zungula must not equally be allowed to direct a question to Advocate Mbofu the same way we did with Honorable Heron. Honorable Zungula can deal with the witness on stand, but not Advocate Mbofu. Thank you very much.
Thank you, Honorable Ngola. Honorable Zungula, you are going to be given an opportunity to ask Advocate Mbofu when we're done with this quick sessions. I would want you to pose correctly if you've got any other questions to the witness, and I will give you an opportunity to ask Advocate Mbofu.
Chair, I'm not sure what you are referring to because my question is addressed to the witness. I did not mention Advocate Mbofu, but let me proceed.
Oh, okay. Well, go ahead, Honorable Zungula.
Yeah. So the issue of Parliament taking a resolution to form a Section 194 committee to establish the fitness of the public protector to hold office. According to you, is the inquiry to hold fitness the same as removal? Is it not two different processes? If what we are, if this is an inquiry or if this is a removal process, which process has been done to actually get to determine the fitness? That is my first question. The second question would be on the principle of fairness, is that this process is not operating or is not proceeding in a way that is outside of the other processes that may have been taken by the Speaker or by the President of the Republic. Therefore, is it fair that the process continues, whereas there are other grounds which are still going to be, going to be ventilated in a court process, whether they were rational and whether they were correct to do so? So should this committee proceed under that cloud whereby the courts are yet still to decide on a matter that is going to affect this process, meaning the suspension of Advocate Mkhwebane? Thank you.
Thank you, Honorable Zungula. Mr. Ebrahim.
Thank you very much, Chairperson. My understanding and opinion is really that Parliament was entitled to establish this committee as per Section 194(1)(b) for purposes of undertaking the considerations as to whether Parliament should adopt a resolution for the removal of the public protector. So that process, in my opinion,
just closer to your mic so that you can.
That process, in my opinion, is a perfectly legitimate process, and it had been taken in terms of the Constitution. So I have no difficulties with that. The question of Parliament taking a resolution on the establishment of the committee, I think it is the appropriate resolution. There were several steps that were taken before. The one step that was undertaken was the rules and the predetermination and definition of really what misconduct is all about. That's one process that took place. Second part of the process was an inquiry by a panel, which related to the question as to whether there was a prima facie case this process is a very specific one, and it's in terms of 194(1)(b), and it's also appropriate. And I believe that this committee is properly vested with that opportunity to consider the merits and arrive at its resolution or arrive at its recommendation to Parliament in terms of the resolution it ought to take. Thank you.
Thank you, Mr. Ebrahim. Honorable Olamisa.
Thank you very much, Chairperson. And good evening to all. I'm happy that the Concord has in one of its judgments said that people can be fallible and make mistakes. And I also heard you during a cross-examination by Advocate Mpofu that you don't fully agree with some of the Concord or court judgments. Given the Zondo Commission's findings, which has pointed fingers to the misuse of public funds, even President Ramaphosa has accused his colleagues in this regard. Here we're meeting to deal with some of the charges. One of the charges against the public protector refers to the public protector's attempts to investigate the CR17 funding. Right now, nobody knows whether there were state funds which could have gone via the CR17 campaign. So for this committee to be clear, we may have to call the president, because maybe, not accusing anybody, that some of the judges made a mistake, because the public interest is still there. The people want to know, not necessarily to say private company funded so-and-so, but to make sure that the public funds have not gone through that. Read this with what the Zondo Commission has said, and even the president himself. So lastly, as I said, would it be possible, would it be fair for this committee to invite the president just to make sure that everything is above board, because we are not going to succeed if we are going to ask the public protector and grill her alone based on the judgment, which might have been a mistake. But we want to know from the president, take us into the confidence, the whole country. I rest my case.
Thank you, Honorable Olamisa. Mr. Ebrahim.
Chairperson, the answer must be a fairly simple answer from my point of view, in the sense that it deals with the merits of the case. This is a matter for the committee to decide in terms of reference and how it wishes to undertake its work. How the committee decides on matters is something that's totally outside my purview and my brief. So I'm afraid I'm not able to answer that, except to say that this committee is able to take all decisions that are required relating to the charges that this committee is having to undertake. How it wishes to investigate those issues are dependent on what directives the committee issues. So I believe that as a member of this committee, Honorable Holomisa is entitled to raise the issues and for the committee to decide as is appropriate on the matter. It is not a matter that I could potentially have an opinion on. It's something totally out of my brief and remit.
Thank you, Mr. Ebrahim. Honorable Mauta.
Thank you very much, Chair. Chair, I'll be very brief. And first of all, maybe thank you that you allowed this committee to continue before 4 o'clock, beyond 4 o'clock. Now, Chair, we are sitting here the whole day with the expert. And in his first paragraph, he says he was approached by the evidence leaders for the purpose of providing assistance in relation to contextualization of the PP within the constitutional and framework of South Africa. Now, having gone through the day and it becoming very clear that he's actually not an expert, and I'm saying this with the greatest respect, how does Mr. Ebrahim think this is assisting this committee to arrive at some conclusion on its fact-finding mission? That will be my first question. The second one is in relation to page 54, pagination 62, under H, conclusion on removal. So it says that, he says that in 99.2, engaging in a process in terms of section 194 of the Constitution is a critical means of ensuring accountability and the rule of law. It is in the public interest for the process to be final. Can he advise us or guide us which process he's talking about that must be final, and what does it mean when he says it must be final? The other question will be in relation to section 194 of the Constitution. Would you, Mr. Ebrahim, say that we're not yet dealing with the DA's motion, which speaks about the removal of the public protector, because this committee is not dealing with the removal of the public protector? And then the fourth question will be, Mr. Ebrahim, what do you think the impact will be of the upcoming court case, which is sitting in a few weeks, in the court case of Advocate Busisiwe Mkhwebane? So what do you think will be the impact if the court finds in favor of Advocate Busisiwe Mkhwebane? And what guidance would you give to this committee in that regard? The last question, Chair, with your indulgence, is that, and you can comment if you want to. What's your comment on the fact that the PP was suspended immediately after she confirmed that she's investigating the Palapala Farm saga? I thank you, Chairperson.
Thank you, Honorable Maut. Mr. Ebrahim.
Chair, can I get your indulgence?
Just pause, Mr. Ebrahim.
Chair, I'm not quite sure if it's fair to the witness to ask him of what is his views on a matter that is before court. The question by Honorable Mauto is correct, but I'm not sure if it's fair for the witness to answer a matter that is before a judge of the court of law. I wanted to allay the committee and yourself, Chair, on that matter. I'm not sure if I'm right or wrong, but I wanted just to allay the committee and yourself. Thank you.
Thank you, Honorable. Thank you, Honorable Mola. The order is not sustained. I proceed to Mr. Ebrahim. I am actively watchful of anything, and I will listen to his responses, including in terms of Rule 88 on reflections. 88 rules of the National Assembly. It's not about sub judice. It's on reflections. Mr. Ebrahim.
Chairperson, yes, the first point.
Of the committee. Thank you, Chairperson.
Go ahead, Mr. Ebrahim.
Thank you very much, Chairperson. I'll start with the issue of paragraph 99(2), the question of this committee and undertaking a process in terms of section 194 as a critical means of ensuring accountability in the rule of law. The question was raised as to whether it's in the interest of the process to be final. The issue is that it would be inappropriate for the constitutional health of this country to leave matters as serious as a matter relating to the public protector, which is such a senior officer, to leave it pending and lingering for too long. It would be inappropriate, especially to the poorest of the poor and the people who are expecting relief from the office of the public protector. And so the soonest matters of this nature can be resolved, it is in the best interest of the constitution. I would imagine the constitutional health of this country. So finality is always an important one. It would be inappropriate to leave matters like this to linger for too long, because I think it's harmful. On the question of section 194.
Just look at the mic so that your voice projected to the mic.
Sorry about that.
You might have to take your notes closer to the mic.
Yes. Chairperson, what is the committee doing in terms of section 194? I think your rules, your terms of reference and the rules are fairly clear in terms of what the committee has decided upon. That is not something that I've applied my mind to, except for the fact that I know that the committee is established in terms of section 194 1B and applying and about to apply its mind. And I believe that the way in which it would apply its mind and complete its work is something that would be up to the members of this committee in terms of how it decides to undertake its work and deliver on its mandate. But that's something that I would leave as such. Thank you very much, Chairperson.
Thank you. Honorable Ngola.
Well, thank you very much, Chairperson. I think, Chair, on the first question that was posed by Honorable Mahlaule on the significant difference between the public protector as a person and the institution as a Chapter 9 institution of government has been covered. Because even the language use of the document, Mr. Ebrahim, you have prepared for us, is speaking about two things. The public protector as a person and the public protector as an institution. The second issue, Chair, is the issue of, which I think as well has been taken care of, because there was an issue that we discussed even yesterday that speaks about at what time do we declare the committee on section 194 to have resumed its work. There is an issue, Chair, that is referred in section 194. 194 subsection 1B speak about the public protector, the auditor general, or a member of a commission established by this chapter may be removed from office only on, let's leave other than go to be a finding to that effect by a committee of the National Assembly. Then let's go to 194.3A. May suspend a person, the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Both sections are mentioning a committee of the National Assembly. Are they referring to the same committee? Is the same committee? 194.3A is speaking about a suspension by the president of whether the Auditor General or the Public Protector that have been subjected to a parliamentary inquiry. I want to check from you that to what extent does this committee get involved in what is mentioned in section 194 subsection 3A, the suspension part? Does it fall within our jurisdiction to discuss and pose a view around it, or it remains solely an issue that resides with the powers of the executive? The second issue, Chair, I would like to pose is that part of what is part of the document that you deposed is that it says the public protector must not only discover the truth, but must inspire public confidence that in each investigation, the truth has been discovered. I want us to I want you to a bit elaborate, not only for us, but for the South African people as well, that what does it mean when it says must inspire confidence? Maybe for all of us to understand it better. Another issue is the issue of the three arms of state, which all three of them are established in terms of the Republic of South Africa Constitution, Act 108 of 1996. Namely the judiciary, the legislature, and the executive. Now, because you are part of the constitutional drafters, maybe you'll be able to tell us the intention of having the three arms of government, and what was the intention of their operations in terms of how cooperative should they be amongst each other, all three of them. The last is in terms of the CV you have attached in with the affidavit. It dates back from your experience from constitution drafting and all those things. The education you have been able to acquire within particularly the field of law. The experience that you've been able to amass throughout yourself being a public servant and domestically and internationally. The number of years at which you have been doing this work. Does that alone not qualify you as a person who has got expert opinions in matters of this nature? Thank you very much, Chair.
Thank you, Honorable Nola. Mr. Ebrahim.
Chairperson, yes, I've been told that I should not be unnecessarily humble about these matters. The point is that, yes, I have more than 25 years experience in the field of constitution making and constitutions, and I do believe I have substantial knowledge. I do believe I have a particular expertise which has been appreciated by international organizations, being the United Nations and several other international organizations, and many governments have been happy to receive advice from me. So in that regard, yes, I do regard myself. I should regard myself as an expert. The question of intention of you ask a very wide-ranging question relating to the intention of the constitution makers relating to the three institutions of government. If you look at really what the Constitution did when it established the democratic dispensation, is that effectively it created a new executive and a new legislature. It did not change the judiciary. Judiciary remained by and large intact and remained. It did not abolish as it did Parliament or the executive or several of the other institutions. But the three institutions of government continued in terms of the new constitutional dispensation and under a new mandate specifically to try and implement the new dispensation. But the cooperation, the way in which the branches of government were required to interact based on the new constitution required this new, what was defined in the new chapter referred to as cooperative governance. It's something, a concept that had not been entertained or considered before. It is novel, it is new, it's something I think the government or country is still trying to get its mind to come to grips with in terms of how to deal with it effectively. But cooperative governance and cooperation between not just the three branches of government, but the different spheres of government at the vertical level and at the horizontal level is something that is a project that is ongoing and continuing. The question of truth inspiring confidence, I think it's something that you can refer to, whether it be for the police, whether it be for the courts, whether it be for other institutions of government and state. The way in which institutions of government undertake the activities must necessarily inspire confidence in people. However, the public protector is a particular case in point, because the public protector does serve the interests of the poorest of the poor, and therefore special attention must be given to them in terms of inspiring confidence. So when this committee looks at oversight of the public protector's office, my own view is that one of the key issues you'd want to have in your mind as a member of this committee is, what do we do, or what does a public protector do to ensure that they inspire confidence? So those are parts of the conversation that you'll undertake with the public protector as part of your normal oversight functions. And I do believe that it is an important question of how you go about inspiring confidence. So it is a mandate and a brief and a requirement that I hope this committee or the National Assembly will consider as part of its engagement and discussions with the public protector. In terms of Section 194(1)(b), I think that I can sense the confusion that has been going on about 194(b) and what this committee is. My understanding, as I said before, and I want to repeat here, is I believe that the 194(b) is what this committee has been established for, and I hope it will be successful in the work that it undertakes. Your first question really relates to, again, a question that has come up over and over again, because there's been significant confusion around it, which deals with the public protector versus the person in occupying the office. And I think it's still a matter of some confusion. I'm saddened that the discussions today hasn't solved the issue and addressed the issue. Hopefully this committee will apply its mind to trying to gain clarity about this, because it is an important matter in terms of how one deals with the public protector from a point of view of the person occupying the office and the office itself. Much of what you have referred to deals with the institution itself, in terms of what the institution is required to do. There's another part of what this committee that deals with, which is really not the institution per se, but the person occupying the office. And I think that there's a distinction between the two matters that I think needs to be considered much more carefully. Chairperson, I hope I've tried my best.
Thank you, Mr. Ebrahim. Honorable Sheikh Imam.
Thank you very much, Chairperson. I know it's in the late hour, but I will try to be as brief as possible. But let me first of all say to Mr. Ebrahim, I think we are quite confident and convinced that, of course, you have the necessary expertise and qualifications. And I think that is loud and clear. But I must tell you that, given the fact that you say you have a lot of qualifications, you've been in the public sector, I think you will understand and appreciate the concern that is being raised, particularly from party political perspectives. And I think you would agree with me, hardly ever, I think, barring one case in the Parliament National Assembly, has anybody ever voted against the mandate of their political party. So that raises a question on objectivity and independence. I'd like you to comment on that. And I do know the ideal situation is that you have to be independent, you have to do the right thing, but the question is, do we? Would you agree with me, Mr. Ebrahim?
Chairperson. Oh.
You are muted.
Evaluating her qualification experience, and we found that she was.
We lost you, Honorable Sheikh Imam.
Sorry about that.
Maybe for now, just switch off your camera
and start where you were asking the question whether he would agree with you.
Okay, I think you don't want to see my face. Thank you, Chairperson.
Just for a moment, just for a moment.
Yeah, I
It's
think
not a bad face.
No. Would you agree with me, Mr. Ebrahim, that at the time the public protector applied for this position, we've been through the entire process, looked at their CV, looked at their qualification, looked at their experience, and found her to be fit for purpose, the ideal candidate, and appointed her. I'm sure you're going to agree with me with that. And I think you have agreed that she's got the necessary qualifications, and there's no doubt about it. Will you also agree with me that from time to time, like Parliament and all structures and all government departments and many others, seek opinions from senior counsel or other legal experts before certain decisions are taken and or implemented? You will also agree with me that there's been many instances in the country, and Parliament is one ideal example. How many matters have we gone to court and not been able to succeed? Or if you look at even in the Oscar Pistorius matter, after judgment, the matter went on appeal and it was overturned, and we're having these things all the time. To err is human, there's no doubt about it. We can often make mistakes. Now, I agree with you when you say that the Office of the Public Protector has a responsibility to ensure, there's no improper conduct, high levels of ethics and accountability. I must agree with you. Now, the question is, given what we have at the moment, and the fact that in this country currently, if you found that there's been 18 out of 257 municipalities only that had a clean audit, and here you've had the Office of the Public Protector, which is not really relevant in the particular matter, but to some extent in terms of accountability and clean governance, it does say something. Perhaps you'll deal with that at a later stage. But I think the point I'm trying to get at here is this, that whilst there's been many matters, and there are many instances in the country of decisions that have been taken with legal experts and opinions from outside that we failed or did not succeed with, including, and I'm talking about the courts to a very large extent. I feel that there appears to be some obsession with the public protector herself in wanting to only deal with the public protector and not many others who have also cost us or may have cost us a lot of money and not being able to do justice to the positions that they have. So the question is, why only, going for the public protector when so many others fail? Now, could you explain to us why 2/3 majority is needed to remove the public protector from office? And if that is the case, which I agree with, then should it not be that even this committee, when it reaches its findings, I'm not sure, maybe you need to clarify this, that when we reach our findings, are we supposed to make recommendations to Parliament or not? But whatever it is, the report that we are going to give, should it not also be approved by a 2/3 majority, because otherwise you're defeating the purpose before it actually goes through to Parliament, because remember, everybody else has not sat on this committee we have. So I think it will be only fair that we go to the route or go the route of ensuring. I want you to comment on that, whether we should consider that or whether it's the right thing to do or not in terms of having a 2/3 majority decision on whatever reports we are going to have for Parliament itself. I think I'll stop there, but please give us clarity on, because I think despite all the discussions on the issue of the responsibilities of this committee, it is still not clear what we are going to do, what do we give to Parliament, and what is the next step after that? Because normally what happens in the committee, you make findings, you make recommendations, you give a report to Parliament, that Parliament, the report is adopted and then implemented. So I'm not sure really in this case if this is exactly what the situation is going to be. So maybe if you can just, give us a clarity on that. Thank you, Chairperson. Thank you very much.
Thank you, Honorable Sheikh Imam. Mr. Ebrahim.
Chairperson, I think there are a whole host of questions that have been asked. I hope I'll do some justice. Let me start with the last one first. The findings of this committee must go to Parliament. And in terms of the rules of Parliament, I believe it's very clear that It doesn't require either a secret ballot or a two-thirds majority. It requires a decision in terms of the rules, and there'll be a majority decision, and the minority decisions that or minority views in this committee should also be recorded so that the National Assembly has access to that. That's my reading and my understanding of that. So I don't believe a two-thirds majority is required here, but a two-thirds majority in Parliament, yes, is required as a supermajority to succeed with the removal of a public protector. Of course, we can all agree that mistakes have been made in all aspects and areas of government, and one could legitimately ask why one institution and not another institution. But that's not a good argument. The fact that Parliament and the executive has failed in so far as other institutions may not be called to account is quite a different matter from this committee's responsibility. That is a matter that members of Parliament should undertake in Parliament, to say we are not undertaking our work as Parliament effectively. And so Parliament must ask those questions of itself. Why is it not taking up that work? But it's not the work of this particular committee, and this committee should not find itself occupied by that. As to whether there have been mistakes, I think mistakes have been made throughout government. That's nobody's hint that one. The question is how one deals with it, and that is a matter for Parliament, but not in this particular context, in the broader context. Seeking opinions of senior counsel, I think we've been through that one several times in terms of who bears the costs and how and what's the outcome of it. I think many institutions have sought legal counsel in different respects, and some have been good, some has not been good. I think perhaps it may beg the question as to how we go about securing support services, whether it be senior counsel or whatever other support is required, legal or otherwise, and how one profitably utilizes the meager state resources that are available to us. The question as to whether the public protector was fit for purpose is not a question that one can answer now, because the public protector was appointed on that basis. And so we've long passed that. We have long passed the fact that a public protector was appointed and regarded as fit for purpose, and there's been no issue in my understanding related to that. What is at stake is a totally different story. The first question that was asked is the concern as to party decisions taken along party lines. Invariably, I've seen debates and discussions in Parliament over the years, and people on different occasions have argued that we should take decisions based on not party lines but institutional lines, and sometimes a vote of conscience, and different arguments have been put forward. Invariably, these matters will get taken to party, and sometimes party whips win the day over MPs, and that's internal party discipline. But notwithstanding what internal party discipline may be, our obligation as experts on this matter is to seek that however you apply your mind, you apply your mind as an institution. Whether you actually abide by that is something that I think is up to the conscience of individuals and the party leaders themselves. I have no doubt that party leaders will want to use the whip and decide or have some influence over decisions that are taken. But I do believe that it is in the best interest of this committee and the National Assembly to decide on this matter, however it decides this matter, when it is required to vote, to consider from an institutional point of view rather than a party perspective. That would be the appropriate way. Whether that gets undertaken, as I said, is a matter for parties, and that we cannot prescribe or deal with. Chairperson, thank you very much.
Thank you, Mr. Ebrahim. Ms. Honorable Mananis.
Thank you, Chairperson. Mr. Ebrahim, my question is having followed the process from the inception, has it, in your opinion, been fair, being transparent, being open? And I want to check with you if this particular process is properly followed in terms of Section 184. Other questions, Chair, have been covered by other members. Thank you.
There you go.
Chairperson, yes, thank you. I wish I could answer in the affirmative as to whether I had full knowledge and understanding of the full process and all of what you have done. If I answered that in the affirmative, I would be lying. I had obviously been because my interest in the work of Parliament and the areas that you are dealing with, I'd obviously, as an expert, had paid some attention to it. But whether I've studied in detail or not, no, I've not studied in detail. So I've been not well versed with all the intricacies of it. But yes, I have general knowledge. So it would be inappropriate of me to comment further than the subject matter of what I was asked to focus my attention on.
Thank you, Mr. Ebrahim. Honorable Lizib.
Oh, enkosi mhlali ngaphambili.
Thank
No. Thank you, Chair. Good afternoon to honorable members, the Public Protector team, and Mr. Ebrahim. Yeah. Maybe my first question probably is linked to what Honorable Mola has said. I'm not sure whether it's a matter of confidence or not. What is your understanding of an expert? Because we keep on running away from this thing. I tried now to say, I always been using common sense to define an expert. So let me consult a dictionary. The definition here says, is a person who is very knowledgeable about or skillful in a particular area. Then it says in bracket as an example, health expert. Now, I'm not sure whether it's a subjective relationship with yourself that makes you not to be able to define yourself whether you're an expert or not. Because for me, I would stand up and say, as far as I understand, a person who's an expert may not necessarily be someone who has got all the answers or who knows almost everything. It is someone who at a particular moment may be more exposed and a better understanding of that specific field. I think that is the first question. Maybe if you can help with that, just a brief on that. The second one, I'm very interested on 87, on your report, but I want to stick to your report. 87.1, it's just a matter of interest. I won't read the whole question. It says, while the president is responsible for the act of removing the public protector from office, I still don't understand because it says responsible, but the following statement says something completely different. It says he may. Now, the use of the word may, to me, is not a directive, it's a subjective term. Now, is it possible that a committee may make a recommendation? I'm just saying hypothetically, because we said it's a new terrain, this one. Is it possible that at some point, or even any time, even from now, that a committee may make a recommendation, or there may be an ultimate process of Parliament that says, yes, now we are of the view that can be removed, and the president may decide not to? If I read this correctly, the way I'm not taking it from the Constitution, I take it from what is written here, because this becomes discretionary, that he may apply his discretion or her discretion if that president, depending who's been the president at that moment. I think that is my first issue, if there can be clarity, including what is the definition of removal. Because if Parliament, it seems to me, when it would have taken a decision, that would be a decision to remove. The president will just put a signature confirming what Parliament. So who is removing between Parliament and the President, if I follow what is written here? Just quickly, Chair, I will try my level best. I've put some of the things here. There is one part, it talks about the 65. Yes, 65. Please explain what, I didn't know whether it's referring to the public protector or is referring to members of Parliament, or it says, let me read it, it says, Chair, just on info, it says, no person may conduct or assist in an investigation. Then we put in bracket, in which he or she has any, what is it? Pecuniary interest or any other interest which might preclude him or her from performing his or her functions in a fair, unbiased, and proper manner, unless that person works in government, performs a public function, or is subject to the public. So I assume it makes reference to the public protector. I think that's jurisdiction. Now I was trying to follow from whether it's from CD, but 65. If there can be clarity with reference to who. And secondly, on 71, that's my last one, Chair.
It must be here.
Most definitely. On 71 at the which it says that the public protector may be held personally liable for cost incurred during litigation if guilty of bad faith or gross negligence in conducting litigation and discharging her constitutional obligations. That's a constitutional court ruling, my understanding. Now, the problem is that, is it a constitutional prerequisite, or is a court ruling by the Constitutional Court? I'm raising this thing because automatically, yes, that is the apex court. But according to what is here, if that ruling of the Constitutional Court was not there, let me put it that way, what could have been a recourse? Because when I look at this thing, somebody will say, it says, if found guilty. Now, the ruling of the court was not necessarily that there was a case. It became a ruling in a different case. Is there a way that this is supposed now to mean, I know you were very skeptical to talk about amending the Constitution. This will supposed to mean there has to be a reconsideration or a determination whether this should be made a constitutional provision because it's a ruling of the Constitution.
Thank you, Honorable Mr. Ebrahim.
Chairperson, thank you very much. I think the question of personal liability for costs in any institution, just not just the issue of the public protector, is an opportunity for the court to express its displeasure at what has taken place in the case it has dealt with, and it does so purely as a punitive matter, but as a punitive decision, but on the basis of very limited conditions in which the court feels that there are conditions that compel the court not to impose the costs out of a case from a case on the institution itself, but rather on the person because of the conduct of a person. So it's a very peculiar interest. It doesn't deserve any consideration as a constitutional amendment, but it's purely a matter that the court decides upon the way it intends to. In fact, I would caution against trying to even include that in any constitutional amendment. The issue of self-interest is a matter that it goes without saying. It is a matter in which one should avoid any institution or organ of state or public body that is involved in public administration to have personal interest in the way in matters that are being undertaken, and one has to be cautious about how one deals with that. So that's very important. Paragraph 87.1 perhaps could and I hear you on that, and perhaps it could have been phrased a little bit better. The issue is that the final task of removal is that of the president, but it's done on the basis of a resolution of Parliament of 2/3. And so he merely signs, and that's the decision. I don't think it is a discretionary issue in that he has a choice on that. So I think the president removes on the basis of, on the strength of a decision of Parliament, which is by a 2/3 majority. And the issue with regard to confidence on expert, I regard me as being educated. Thank you very much.
Thank you, Mr. Ebrahim. You're done?
Thank you very much.
Honorable Mankenzi Klape.
Thanks, Chairperson. Just registering my presence with the video, I will shut it off in order to be more comprehensible. Chair, let me go straight to the issues that Mr. Ebrahim went through. He went at length to explain the immense wide powers that the PP office holds. And I'm not saying the person, I'm saying the office, powers that resides in that office. I looked at item 26.1, issues that are outlined on 37.4, 42.1, and the fact that the Constitution is silent on what we're busy with here in terms of fitness. And as such, we had to rely mostly on the issues of jurisprudence as outlined on 48.4. These powers, Chair, are compounded by the PP Act 23 of 1994. Now, having listened to all this, I just want to find out from Mr. Ebrahim as to, besides the Constitution that is lacking on some issues of fitness and propriety, besides the Constitution and issues of jurisprudence, do we have any other tools that we can rely on to drive this process as this committee? I have noted from yesterday that we're talking about uncharted water vision territory, but are there any other tools that we can bring besides this one? Two, Chair, can the incumbent of an office of PP challenge issues of jurisprudence? I want also to find out, and this is more aligned to what Honorable Mananiso asked. And I would just mention that for a greater deal, I had Advocate Mpofu speaking about this process being tainted with illegalities. What is your take on that, Ebrahim? Having checked where the committee started and where we are today, even calling witnesses. My last question, being here for today and having heard yesterday, looking at where we're coming from, the chairperson indicating that we are on phase 2 as you was opening yesterday. There are now proposals, suggestions that are coming. For an example, that we get legal advice. Recent one is that the honorable member said we must even call the president. What will be your advice to the committee that has adopted terms of reference, that has agreed on the directives, on the proposals that are coming whilst we have already done this and we are, the train has left almost? Thank you, Chair.
Station. Enkosi Honorable Mangezi Tlape. I now recognize Honorable Maneli. Honorable Maneli. Oh, sorry. You have to respond. I've just skipped you. Mr. Ebrahim. My apology.
Chair.
Not a
Chair.
problem, Chairperson.
Chair, I'm not sure. The person who has asked the questions on virtual, and this thing is off.
You can hear.
Yeah, he can hear. She can hear. Okay. Okay, no, that's fine.
They can hear.
As usual, I start with the last questions first because I can remember them easier. The issue of whether the process is tainted by illegality. I've expressed myself in this meeting and I've been asked for an opinion. I don't believe that the process is tainted by any illegality. It is a view that the advocate Mpofu has presented, and I have full respect for his argument. But
again, I want you to come closer to the mic without kissing it, but just close.
I
just
have
keep
a
that
different
balance.
view on that. Can the PP challenge jurisprudence? Yes, there's no question. I mean, the PP is not precluded from exercising her rights in terms of availing herself to the courts to seek redress, and that is well within her rights. So there's nothing that can preclude her. The question of whether there are any tools, the Constitution is silent on the question of the fit and proper requirements, and we relied on jurisprudence. Are there any other tools? Well, I think it's a matter for this committee, which is why when responding to this brief, we try to present a list of the final summary, which will define really the details of what we think has been raised by fit and proper. I would imagine that should this committee deem it appropriate, you would either in the rules or in the legislation seek to define fit and proper in much more detailed terms in an amendment of the legislation requiring the appointment or the Public Protector Act and so on. You could consider, so you're asking the question, are there any other tools? Well, the tools that could be available and open to you would be either rules or would be legislation and an amendment to that. But yes, what we thought was important was to present to this committee was a view on a reading of not just the Constitution and legislation, but also the rules and jurisprudence on the issues, and hopefully it has improved the knowledge on the issues, and ultimately National Assembly is the lawmaking body, and you have the authority to decide on how to determine what laws need to be passed, and that is your mandate. And should you feel that matters coming out of this committee's work may inform or provide you with a better opportunity to define things a bit clearer in the law, then as a National Assembly, you should consider it. So are there any tools? Yes, the tools are in your hands. It's for you to decide. Thank you very much, Chairperson.
Thank you, Mr. Ebrahim. Honorable Boyce Maneli.
No, thank you, Chair. Mr. Ebrahim, maybe before I ask a few questions I need to ask, Chair, maybe just to reinforce the point you've made, so that when I ask the questions, you do not think I'm opening up a ruling you may have made, because you've shown the rule book that you have made a ruling which you would have foregrounded it with the factual journey of the committee yesterday, and further clarified that indeed the committee is not convened to review the discretion of the president as it relates to the part of the suspension. So as I will ask these questions, they are really not about opening a rule, but just to reinforce them. And I take it that we have similar understanding, Chair, that over and above the directives to be adopted, the rules of the National Assembly are still in force and they apply to all committees of the National Assembly. So that's the reinforcement. I thought I should start there. And therefore, we have spent a bit of time, even in the engagements you've had with Advocate Bof, on that EFF and others versus the speaker. Maybe just to reinforce the point, the 180 and the 181, I just want to get an understanding that I can live with from the meeting. My understanding would be that those two really speak to the process. Yes, you identify the problem, but you must set up rules. But it also says that the National Assembly will determine that. It doesn't say it should
just lift your mic.
It shouldn't be done in a particular way, but the National Assembly makes that determination. And in making that determination, part of what it has made as a determination in how to follow this process would have been a creation of an independent panel, which also came to some conclusions. And post that, we are where we are today, which is what was said to be the factual chain. Would you say that is in compliance to such a judgment? Because that's very important for South Africans to understand what it is exactly. Because the Assembly has done all this to ensure that this process is properly guided as expected in those. So I just wanted to check that, because it would appear that that question of whether this process is legal or not legal, we spend time on those to try and justify illegality, which could not really come out as far as I'm concerned. And I'm using this based on the engagements that when you refer to the president process, you're interchangeably referring to the public protector process. So if you can just confirm if the processes that Parliament would have followed in setting up this committee to perform this task, including the independent panel, whether they do not satisfy this judgment in that score. And I'm referring to 180 and 181 judgments there. The second point there, Chair, is just to follow up on a point raised by Honorable Ngola. I didn't get the response quite well. And that's why I want to rephrase it. This is the question I said I'm not opening. The point about a ruling made by the chair already. But I just want to take D, where you talk about 39 there, the president. The public protector is appointed by the president on the recommendations of the National Assembly. I'm saying it's under D 39 on what you've raised. Then the much talked about subsection of section 194, the 3A, which also is under the president. And I want to take A and B so that I look at it in totality. The A we spent time on was may suspend a person from office at any time, which I think you've clarified what any time means. After the start of the proceedings of a committee of the National Assembly for the removal of a person, right? And I'm saying, if you then take the part about suspension and the actual removal. All these structures seem to cooperate from what I'm raising it in that score. Now, what makes me to raise this is that whether our engagement about discretion or interference, is this not about the spirit and intent of why you said the constitution of the country is special in that it also has included cooperative governance in it? Because it then says that all the roles that are being played, they are still about promoting the objectives of the constitution. Yes, there may be distinctiveness, but in another way, there's also interrelatedness and interdependence, because one decision has to be made by the other for the other to be triggered. But it will not necessarily mean it's interference, because you allow others to also play their role. So I think for me, it's important to just clarify that point. Is this a matter of cooperative governance, or it is a matter where there's probably interference of one arm to the other when they are all working to the promotion of the constitution? Thank you, Chair.
Thank you, Honorable Maneli. Mr. Ebrahim?
Chairperson, I can add very little to what the honourable member said. I think his understanding is perfectly spot on, and I cannot argue with his approach. Very briefly, I think the committee doesn't have any power related to the suspension by the president. It doesn't affect the committee at all. I believe the National Assembly must make its determination in terms of 180, 181, and I believe, yes.
You said it's not in the realm of the committee.
That's right.
Okay.
And the question of cooperative governance is something that is an ongoing, and it says very wide remit and requirement in terms of the spirit. It's more a spirit of cooperation between different institutions of government and the need for those institutions to come together. So I can add very little wisdom to what you have already stated. So thank you very much for that.
Thank you, Mr. Ebrahim. The last honorable member, Honorable Tlagude.
Thank you very much, Honorable Chairperson. Good evening, honorable members, Advocate Mpofu and his team, and Mr. Ebrahim. Honorable Chairperson, let me start by saying that I've been hearing that we shouldn't, even Mr. Ebrahim mentioned that as this committee, we shouldn't be following party lines and all those things. I just want to confirm in this meeting that we, as members of this organization, our party line is to embark on a fact-finding mission. We don't have any predetermined outcome. So that is our party line. Secondly, Mr. Ebrahim, thank you very much for this document that you presented to us since morning. I want you to agree with me if I say that the Constitution provides only for the grounds of removal, be it in Section 89 or Section 194. Then, in the absence of a process that is needed for any of the institutions, or heads of the institutions to be removed, who within the three arms of state is expected to come up with a process for removal, in your understanding? Then the second issue, Honorable Chair, Mr. Ebrahim, if you can take us back as to what was the role, in your own understanding, of the independent panel? And why did Parliament needed the independent panel for? Then I'll go to your page 33, paragraph 49.2, where you say, one requirement of fitness and propriety for a legal practitioner is that of absolute honesty. Then you said, even dishonesty outside the courtroom or in respect of relatively trifling matters can render an individual unfit and improper. Any form of dishonesty under oath can render an individual unfit and improper. So a person like myself, who's not a legal guru, can interpret this somehow. Can you please explain to us so that we can have a better understanding? My little understanding of an oath is that it's taken inside court or in parliament or wherever, but outside, there's no need for an oath. So I just want you to unpack this so that I can better understand the meaning of this paragraph of yours, so that we have a better understanding on this paragraph. Then my other question is on, I think it's 53. It's 52, page 52. Paragraph number 3 on the president's or paragraph 3A. The president may suspend a person from office at any time after the start of proceedings of a committee of the National Assembly for the removal of the person. In your understanding, your own understanding, as this committee, do we have anything to do with what the executive does or doesn't do as this arm of state? So I just want clarity on that one so that we are all on the same page. Maybe some of us, we don't even really understand that. Your explanation in that regard will assist us. Honorable Chairperson, I think the reviewal of rules of the National Parliament, of the National Assembly or of Parliament is a continuous process. And when those rules are reviewed or are established, they are not made for a specific person. They are rules that are established to stand the test of time. And those rules are made to govern the activities of the National Assembly or of the. So in the absence of rules, do you, Mr. Ebrahim, agree with me that the National Assembly or Parliament will not be able to fulfill its constitutional responsibility? Thank you very much, Honorable Chair.
Thank you, Honorable Labud. Mr. Ebrahim, that's the last take from the members.
Chairperson, thank you very much. I start with the last one as usual. I think Parliament operates by virtue of the rules it sets up, primarily because the institution is premised on the rule of law, and all it does is in terms of rules. So yes, I believe the rules are naturally required to be reviewed from time to time. And I believe that is of value. And it would be part of the knowledge management exercise of Parliament. So I believe entirely that, yes, the rules need to be reviewed as and when Parliament feels appropriate. And Parliament should never be static. A Parliament that doesn't review its rules, I think, is in trouble. I've worked with many parliaments throughout the world, and parliaments rarely remain static, or their rules remain really static. In fact, a little known tidbit, which is related to constitutions. Constitutions are generally never amended very quickly. But the truth is that a recent study of more than 200 constitutions suggests that in general, constitutions are almost overhauled completely over a period of, on the average, 17 years. So even something as tight as a constitution, which should not be interfered very quickly, but experience, history has shown that from a study of as many 200 constitutions, even they change. So the answer to your question is that rules must continuously be reviewed for purposes of improvement. And so with laws, including the Constitution. The question in paragraph 3, the power of the executive, I don't believe that Parliament has any other power other than its usual oversight, dealing with the separation of powers, the checks and balances that the Constitution affords you. You have a responsibility to call members of the executive to question when that is required. So those are the powers that you would have. You identified on paragraph on page 33 the issue of absolute honesty. I think that is something that is absolutely critical, and goes fundamental to specifically the terminology used is with regard to legal officers, attorneys, advocates, and so on. And it is something that and includes all other people also required to be fit and proper. And absolute honesty is one of the elements that is required to be present in the conduct. So much so that in some judgments, courts have found it offensive when even outside a court and even in private life, there have been dishonesty. So dishonesty is dishonesty. And where a person has shown an element of dishonesty, courts have asked whether such a person or whether ordinary people should be exposed to such a person displaying dishonesty. So dishonesty is a critically important issue. The question, what is the role of the independent panel? I think that's a question best answered by Parliament itself. I think Parliament deemed it appropriate to undertake an investigation, appointed an independent panel to find out as to whether there was prima facie evidence of a case to be answered. That's a matter that Parliament undertook in its own right. The value of the report is something that you as a member of Parliament will decide on. But that was a role of the independent panel. The question provides for grounds for removal. The process is responsibility of whom. I think we've dealt with that in different contexts. I think this committee looks at whether there's a basis on which to remove. The committee will formulate a recommendation to Parliament, a recommendation that will include the voices of those that disagree. So the minority views should also be incorporated in that. Those views will be tabled with Parliament. Parliament will then consider whether it wishes to place a resolution, and the resolution will be dependent on the requisite 2/3 majority for it to be approved to succeed with removal, should Parliament so deem it appropriate. As to the question of the party line, I appreciate the point that you make. I think that's valuable, and it's heartening to know that no decision had been taken along party lines, and the current exercise is one of a fact finding. So that, I think, is something to be appreciated and respected. I think it is an important exercise. Chairperson, thank you. I hope I've covered as much as I could.
Thank you, Mr. Ebrahim. you can have you can be the first to take a break, get a breather, but don't go away. Stand by. Because we're just going to take a 5-minute body break. Just body break, and then we come back. We quickly deal with the directives, and I'll be inviting my advocate this side. Just 5 minutes. Mr. Ebrahim, so in 20, 30 minutes time, don't go away. Thank you. Advocate Mbof.
Thank you, Chair. Just a quick one. I was just wondering, for the sake of practicality, if you remember there was that issue that you stood over of the questions that were directed at me. If we shouldn't get those questions so that I can use the break as well to.
Okay.
Yes. Without responding.
For the members to ask them now.
Without me responding. Yes.
Okay. Very, very, very fair. I will start with Honorable Heron and go to. But Honorable Zungula said that's not what he was asking, but I will still try him. Honorable Heron.
Thank you, Chair. I think it is important that I pose these questions before we deal with the directives. My question, yesterday we had the opening arguments and we heard a lot about fairness and bias. And then today in the questions to Mr. Ebrahim, we heard about the process being tainted by illegality, what the impact of that would be, whether it would render the process reviewable. And then we ultimately got to Honorable Hendrick's word, futile. And so I think, for the committee, I'm asking if the public protector's case, as presented by Advocate Mpofu, is that this committee is biased, then we must understand that we should get that substantively upfront in some form of motion or submission that there's bias in the committee. If the committee is tainted by illegality, we should be able to respond to it now and not deal with it after we've heard dozens and dozens of witnesses and sat until September, only then to hear that we were biased and tainted by illegality. So I'm asking, is it not appropriate that if it is the case of Advocate Mpofu, the public protector, that there is bias or there is illegality that affects or makes our process reviewable, should we not get something now to address that rather than at the end of the process? Thank you.
Thank you, Honorable Heron. It is not going to respond. And hope is noted that, except that for you to remember that it would not be a new question asked. This would have been ventilated in court. That the speaker and the committee being accused of illegality, but we'll get to that when he responds. In the Western Cape High Court, these issues would have been ventilated. Let's take a 5-minute body break. We'll go to him.